This hearing is in the matter of case number CA002-2022 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Robert French. The hearing is being held by way of video conference in the DIFC court in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by HFW Middle East LLP. Lead counsel is Mr. Stephen Doherty. The defendants are represented by Seoul International Ltd. Lead counsel is Mr. Michael Patchett Joyce. Thank you.
So as I was saying just now, there's some issues about last minute submission being put in.
Your Honour, yes. Perhaps for the record, I could just clarify that obviously this is an appeal, so I am actually acting on behalf of the claimant respondent, and my learned friend Mr. Doherty is acting on behalf of the defendant appellant. That clarification may have no consequence at all, but I thought I would just read that into the record. Your Honour, so far as last minute additions are concerned, there is a very short covering note from me, and the purpose of that was because when I was drafting the skeleton argument of the claimant respondent, the footnote on the introduction said that at the time of drafting the argument, the appeal bundle was not available to the writer. A cross-referenced version of this document will be provided as soon as practicable. So what we have done is to add the relevant cross-references in red, and we've uploaded that. In the course of looking at my learned friend's skeleton argument, he had raised, I think, 3 further cases. They may not even be referred to because they are relatively tangential to what's before the court. But having done that, it seemed that and I hadn't obviously had an opportunity to respond to those because these were exchanged skeletons, not sequential skeletons. I thought it was perhaps advantageous just to cover that in a very brief note with a further authority, which again I may not refer to, but which is there for the sake of completeness. And I think that that covers, and I hope explains, the reasons for last minute uploading. There was also one reference, I think, to the White Book, the English White Book, which I don't think had found its way to the bundle. It's referred to in my skeleton. Again, we may not need to spend any time on it, but it's there for the court's reference should it be necessary.
Mr. Doherty, I'm going to suggest that we will go on with the hearing. When it comes to Mr. Patchett Joyce referring to his note, we'll decide there that if you need time to reply, then we will allow you to do so later, Mr. Doherty. So that let's skip over that issue, and then if at the end of the day Mr. Patchett Joyce thinks that he has to refer to this note, and if you, Mr. Doherty, is not ready to reply, we'll give you time to reply in writing or by email later. If that's
yes,
the case,
yes,
then,
yes,
okay.
my lord. I think that seems like a sensible way to proceed. You have obviously the appellant's objections on record as well. We'll see what the respondent has to say about the note and take a view then.
Okay, so let's start with you can start with your submission, Mr. Doherty.
Yes, thank you very much, my lord. As you will have gathered, this is an appeal concerning the penalties regime set out in the DIFC employment law. You've had my skeleton argument, which hopefully you'll have had the opportunity to read already. From that, you'll no doubt have gathered this appeal concerns so it's relatively narrow points on the proper construction of the statutory provisions and when penalties fall to be applied. In terms of structuring these oral submissions, I intend to take those points in the order that they appear in my skeleton. So that's to shorthand the set-off argument, the pending dispute argument, the unreasonable conduct argument, and the recoupment of benefits argument. And what we say about that is that each of those grounds in isolation is enough to overturn the judge's findings on penalty payments. So none of those points are interrelated in a way that if one point fails, another point fails. But before coming on to each of those issues, what I had hoped to address your lordships on was the context in which this appeal arises. And there are two things really that I mean by that. First, there's the context of this case itself and the judge's overall findings. And whilst, of course, the findings of fact made by the judge of first instance are not issues under appeal as such, we say that the factual context and the conclusions reached by the judge are nevertheless pertinent to how we say the law should operate in this case. And I'll come on to explain that in a little more detail in a moment. The second thing I mean by that is the legal context, that is, how the legislation as presently drafted came about and is intended to operate. And what we say about that is that the judge's conclusions at first instance cut against the protections for employers that were built into the new employment law as it's currently framed and as compared with the older iteration of that law. So starting with the facts, I'll try and go through this as briefly as possible, but as I say, some overview of the context is important. At first instance, the respondent claimant claimed 7 heads of loss with respect to his alleged post-termination entitlements. Those were for bonus payments, a per diem allowance, payment in lieu of notice, and payments for end of service gratuity, accrued annual leave, and then expenses in annual return airfares and a repatriation ticket. And on top of that, the respondent sought penalties in respect of outstanding sums owed under Article 19. Now, pausing there, it's important to note from the outset what was and wasn't in dispute. That's one of the issues we're going to come to, particularly in respect of ground 2. But first of all, your lordships will no doubt have noted that the claim for bonus payments and the per diem allowance were contested in their entirety. The second point worth noting is that one of the central issues in the case was whether or not the respondent was terminated with or without cause. And that had a number of consequences. What it meant was that there were live issues to be resolved at trial, which had a bearing on, first of all, entitlement at all to payment in lieu. But secondly, it was relevant to the quantum of any entitlements with respect to end of service gratuity and accrued annual leave, because the calculation of either of those sums depended on whether or not the calculation includes or excludes a notice period. So without the resolution of that dispute, we can't calculate what the entitlement actually is. The third point is that the appellant accepts for the purposes of this appeal that quantum was agreed with respect to the final 2 heads of loss, that is the annual return airfare and the repatriation ticket. But the tribunal will have noted that the net effect of that, and ultimately the question of whether the respondent had any right to actually be paid anything in respect of those sums, remains subject to the resolution of the appellant's counterclaim, which the appellant, as you'll have noted, alleged overtopped whatever the respondent's entitlement would have been. And again, your lordships will have already noted what actually transpired at trial. That is that the respondent lost in his claims for bonus and per diem allowance. So that's a little over $44,000. The respondent lost his arguments on termination for cause. So that's around $95,000 that falls away for the payment in lieu, as well as reducing the quantum claimed for gratuity and accrued annual leave. The appellant succeeded in its counterclaim for breach of fiduciary duty. That was in the amount of $71,000, and for the repayment of personal loans, totaling $40,000, and for personal travel, totaling $8,000. And you'll have noted this point, I'm sure, already from my skeleton, but when that all comes out in the wash, what we get is the claimant's claim for end of service entitlements in the region of $106,500, and a counterclaim that exceeded that amount by just under $13,000. So that's just over $119,500. So the context of this case
When Sir
really.
Peter said, Mr. Doty, when Sir Peter said that the gratuity and the accrued annual leave figures were not disputed, that's on the assumption of a minimum entitlement based on termination for cause. Is that right?
Yes, that's right. So the respondent's position at trial was that he was entitled to his notice provision,
Yeah.
and for his gratuity and annual leave to be calculated by reference to that. He was ultimately found to be wrong about that. What was agreed, and I think we dispute the use of the term admitted in that context, effectively what's agreed is what the figure amount will be upon the resolution of a dispute in one way. So the sum ultimately that would have ended up being payable if there was termination for cause was not itself disputed, if that makes sense.
There was a minimum entitlement, which in a sense wasn't in dispute because that was the least he could recover.
Yes, and although of course the respondent's assertion was that he was entitled to more than that.
Yeah, I understand that.
Yeah. So coming back to the overall context of this case, what we say is that we find ourselves in a remarkable situation in which a former employee who's breached his fiduciary duties to his employer and in fact owes his employer money is nevertheless found to be entitled to receive a substantial windfall of a little under $400,000 in penalties. And indeed, when one delves even further into this case, we say that the absurdity of that outcome becomes even more apparent because, first of all, the respondent has lost his case on the many areas of dispute. And that's apparent from Sir Peter Gross's cost judgment. That's at A55, paragraph 11 for your note. But what's said out there is the judge remarking that the appellant enjoyed success on a significant number of issues, and in particular the issue regarding breach of fiduciary duties and termination for cause, which was described as both serious and time-consuming at trial. The second point there is that one of the central reasons behind the judge's conclusion that penalties were applicable was that certain of the respondents' entitlements were admitted, albeit, as I'll come on to, subject to the resolution of the counterclaim. And in my submission, that also puts an employer in a slightly bizarre situation in which, where there is a broader dispute between the parties across a number of issues, the employer is effectively being punished for seeking to assist the court by narrowing the issues that are in dispute, where one might reasonably see that the more prudent, albeit eminently more unhelpful approach would be for an employer to simply issue a blanket denial of all entitlements so as to try and prevent penalties from accruing. And we say that that simply can't be what the law expects employers to do, nor can it be the position that the law expects employers to end up in. That is, seriously out of pocket in a dispute where it, in effect, has won on the principal issues and it is owed money. And I'll come on shortly to explain the precise reasons why we say the judge's conclusions were wrong based on the wording of the statutory provisions and that factual context. But that leads into the second introductory point I make, which is the context in which the statutory provisions are drafted and the policy considerations that lie behind the legislation. And what we say is that those similarly do not support the judgment reached at first instance here. Now, the respondent skeleton and invariably employees in these sorts of cases will allude to the importance of employee protections written into the DIFC employment law. And one can see that as a perfectly fair assessment of why the penalties regime was set up in the first place. But that's only really one part of the picture. Here we're talking about penalties provisions that since their inception have been deliberately amended by the legislature in circumstances where there was widespread acknowledgement of the potential unfairness of the old law to employers. And the first authority that I'd refer your lordships to in that context is the well-known decision in Frontline Development Partners and ADL, which you can find at E43, and where the Chief Justice will be familiar with this decision. And in particular, I refer to, if we go to page, sorry, bear with me, I'm having problems with my bundle. Down to paragraphs 28 and 29. That's a page E52. First of all, we have at the top of that page is a summary from Justice Al-Madani summarising situations in which unfairness was caused to an employer by the operation of the then penalties regime. That's in Leeson Lisco. And the operative part of the judgment starts at paragraph 27. And this is from the Chief Justice, of course. It says, on the face of it, the arguments mentioned by His Excellency Justice Al-Madani, it may not seem fair, that is to the employer. But then is it for this court to say it is not fair if the legislature thinks that's what the law should be? It goes on at paragraph 29. So I ultimately still face the problem of how to interpret the way the appellant submits to be fair to an employer if any of the situations mentioned in lease arises. Unfortunately, cannot replace the words impugned or read into the provisions one or more words or delete them from the provision a word or two. As Article 18 stands, it's grammatically correct, makes sense, and is clearly understandable. The only complaint, if at all, is that it can create situations which the employer considers unfair to him. But if that is what the legislator intended by the use of those words, drafted in the manner it does, it is not for this court to give any other interpretation, no matter how sympathetic the court may be to the employer. So the takeaway point there is the acknowledgement from the court that the old law may have brought about unfairness to employers, but ultimately the court was bound to apply the law as it was drafted then. And that point is significant precisely because that's exactly what the legislator then did, and partly as a consequence of this decision. And if I can refer your lordships next to E84, you should find the covering page for the DIFC consultation paper number 1. So this is the consultation on the proposed employment law. And the relevant part of this document starts at E94 from paragraphs 39 through to 41, which sets out some of the material considerations from the legislature on allowing the court a discretion on the imposition of financial penalties. And in particular, if we then look at paragraphs 40 and 41, what the consultation says is that the mandatory nature of the penalty was criticised in court decisions. That is, decisions such as Frontline were influential in the desire to change the law, as well as in submissions made to DIFCA by establishments in the DIFC, especially in instances where the imposition of such a penalty was clearly unreasonable. Consequently, Article 18.3 of the proposed law was added, and this explains some of the amendments to the legislation that we currently have. But A, we've got exclusion of de minimis claims from penalty claims. So that's a reference back to one of the observations in Frontline about the risk of being 1 dirham under payment and incurring penalties nevertheless. B, we've got a floated cap to the Article 18.2 penalty at 6 months' wages, which didn't find its way into the law, although there's at least an argument that the amendment to the limitation period in the law has a similar effect. But the third is to provide the court with the discretion to waive or reduce the Article 18.2 penalty in circumstances where imposing such a penalty is unreasonable in the circumstances. So in other words, Article 19, as amended, which is the subject of this appeal, has been expressly amended in order to make the position fairer for employers and to cut out instances, such as in frontline, where the imposition of a penalty could be viewed as being unreasonable. That, we say, is relevant to the court's consideration of the intended effect of the current language of the statute.
And 19.4, does that provide a discretion, or is it mandate a waiver by the court where one or other of those conditions, dispute or unreasonable conduct, is satisfied?
Yeah, I'm not sure it would be fair to say that there's any clear authority on that point, and I think it has been argued both ways. There's a view that it is the exercise of a judicial discretion. Some judges have taken that point on board. There is an argument, at least, that the use of the word will in Article 19.4 in fact says that it's not a discretion at all, because if you have a dispute, the court will refuse to or will effectively stop the clock on penalties, if I can put it that way. In my view, and in my submission, that would be the proper reading of the law. I don't think we can read around that use of the word will to impose a discretion that would be that the court may. And I think on the wording of the law, that is the better answer. But I can see that it's up for argument.
There's a translation issue there. Is there
Sorry?
Is there a translation issue? This is just the English language version of a law of general application, I suppose. Anyway.
Yeah, I'm not sure I knew the answer to that. I think our position would be that the word will is the operative provision. I think for the purposes of this appeal, at least when it comes to grind one, nothing turns on it, because ultimately the appellant's position here is that you don't get the trigger point in the first place, so you don't even get to the exercise of a discretion. But I'll obviously come on to that. But the next authority I'd refer your lordships to is just to add a little bit more colour to this issue. The page reference is E42, where you should hopefully find the laws of the DIFC Volume 1. So this is the text commissioned by the DIFC Authority on the DIFC employment law. And what it sheds is a little bit more light on the legislative intention behind the amendments to the employment law. And first of all, we have at the top of the page, beside paragraph number 3, a statement that one of the most problematic features of the old law was that it didn't allow the DIFC court any opportunity to exercise discretion when applying the penalty regime. And so if a sum was found to be owing at the point of termination, the court had to award the penalty and had to do so using statutory calculation. That strict application often led to significant penalties being awarded, even where the amounts outstanding at the date of termination were comparatively small. For example, outstanding expense claims. Just pausing there for a moment, this is a point we'll come back to. But this has some relevance to what is accepted to be the trigger point for penalties biding. But you'll note there the reference to where a sum is found to be owing at the point of termination. That's a point I'm going to come back to and feeds into our grind one, because the issue here is that the point in time at which the penalty starts to accrue is where you have a sum that is due at a point in time 14 days after termination. I'll come on to explain that by reference to the legislative provisions in due course. But the point I'm highlighting here is that that seems to be consistent with the practitioner's text. Sticking on the point of the policy objective of the amendments to the law, what the author is emphasising here is the unfairness that arose under the old law to employers. And similarly, you find at the bottom of that same paragraph, paragraph 3, it starts just below halfway down. There's reference to an SCT decision in Jasmine and Jeremy, setting out one instance where a tribunal refused to award penalties on the basis that the spirit of the old law was not intended to punish employers. And the point there, I suppose, is twofold. One is the penalties regime is not set out to be unduly punitive, but two, that under the old law, it led to a slightly unsatisfactory position where courts were trying to get around it in potentially creative ways.
I'd say we've had this debate in Australia in relation to civil penalties and what their purpose is. And I think the current view is that it's not punitive in the Old Testament sense. It is rather an economic deterrent to contravening behaviour. So it becomes a question of deterrence. And then, of course, the question is whether you colour that with some implied concept of fairness or reasonableness or whatever, which helps you with a constructional choice.
Yes, of course. And I suppose what we would say here is that given the history of the legislative changes, what you have is the competing desire to ultimately and perfectly reasonably have employees paid what is due to them. But what the law doesn't try to do is to seek to unreasonably punish employers where those rights are effectively in dispute. And what we say is that this is the sort of case that falls into the latter category, where there's effectively a net dispute between the parties as to who owes who money, and that the law is intended to capture that sort of situation and holds the punitive effect of the penalties where there is, from the employer's perspective, a reasonable right to withhold payment of those entitlements. Halfway down this page, paragraph 4, we then have discussion about the problematic features of the penalties being applied, particularly where there's protracted employment litigation. In effect, if you've got a long case under the old disproportionate outcomes as a consequence of the invariably lengthy nature of those sorts of proceedings. And then at paragraph 5, what the author says is that the intention of the new employment law was to cure precisely those sorts of issues under the old regime. In other words, we've got a situation where the amendments to the law are rebalancing the statutory provisions in a way that moves what is fair closer towards fairness to the employer, as opposed to being overly generous to employees.
So there's not a general umbrella limit of proportionality, but you would say that the purpose of the, if you like, the exemptions from the penalty to serve a concept of proportionality.
Yeah, so it's to redress the unfairness that arose under the old law to employers. So when we're
disproportionate penalty, which came out of factors that were not really to be sheeted home to the employer, as in the lengthy litigation example, I think.
Yes, correct. So if you've got a case that drags on under the old law, penalties continue to accrue, and what that meant is that you often find these sorts of cases where the penalties payable at the end far outstripped the underlying value of the claim, and that's quite similar to the situation we now have. So even if one excludes the, I suppose, the net position with respect to the counterclaim, we're looking at a underlying claim that's been valued at around $100,000 versus penalties, which are about 4 times that much. And so when one considers what the intention of the introduction of Article 19.4 in particular was, it was to try and avoid that sort of disproportionate outcome. But even that, beyond that, stepping back as a whole, what we say is that the legislative provisions that currently exist are drafted in such a way to avoid a number of types of injustice to employers. And we say that this case is a prime example of where such unfairness clearly arises, particularly given that the net outcome of proceedings is, once you take penalties out of the equation, favourable to the employer. And so the first instance decision here is creating precisely the sort of windfall for the employee that the legislation is intended to avoid. Now, the reason that all of that is relevant, we say, to your lordship's considerations is that we're going to come on to look at what the legislative provisions actually say. You're going to hear arguments from both me and my learned friend as to whether you ought to be taking a broader or narrower view of some of those legislative provisions. And there may well be instances where your lordships find that there's scope for interpretation either way. And where that's the case, what we say your lordships must have in mind is the intentions behind those amendments to the employment law and the fact that they are aimed at protecting employers from unfair outcomes. So in deciding whether to adopt a strict view that would be beneficial to an employee or a broader view which would be more beneficial and fairer to an employer, we would say that the intention of the legislature was the latter. So
problem I foresee is where do you limit when you use that discretion? How do you exercise that discretion? Where do you limit? That was the problem that I had when I was writing Frontline. I mean, how do you use that discretion? Because the nature of employment in the IFC, or rather within the Dubai AER, the nature was that there were abuses by the employers. That is why the government passed that law. But how you want the court to exercise that discretion? How does it exercise its discretion? I mean, then the law becomes very what do you call unsure. You're not sure where one stands when too much discretion is given to the courts.
yes, so I suppose that there are a couple of different answers to that. Really, that comes on to my grind 2, which I will come to after grind 1, because the exercise of a discretion doesn't actually come into play on this appeal if grind 1 is correct, because you never get to penalties being triggered in the first place. And if you don't get to the penalties being triggered, even if one were to take the view that the court had a discretion, it doesn't need to be exercised unless the penalties actually start to accrue in the first place. On grind 2, I will address you on that. Effectively, there is a quite sensible position which has been taken by the courts up to this point. So that's the tribunal and the court of first instance, which effectively imposes a stay or stops the clock on penalties running from the point at which a claim regarding an Article 19.1 right is filed through to the point at which it's disposed with. And we say that that's a very straightforward approach, one that's easy for the court to understand, one that's easy for employers and employees to understand, and one where I suppose the ability of employers to abuse is limited by the court's own procedures. So, for example, if you've got an employer maintaining an unreasonable and unrealistic position in litigation, by issuing a blanket denial, it's open to a litigant to seek to obtain immediate judgment in respect of their entitlements. And that effectively stops an employee being kept out of their money for an unduly long period of time. I'll come on to explain why that position is, in our submission, correct by reference to the statutory provisions in due course. But it might be easier, first of all, to address your lordships on the set-off argument and why we say that we don't really get there in the first place. Before turning to that, it is also worth pointing out that although the penalties regime in the first place is intended to protect employees from being kept out of their money, obviously I've already explained why we need to temper that by reference to what the amendments were meant to do. But it's also worth bearing in mind the acute unfairness that exists for employers in cases like this one, where we do have some netting off of payments. In particular here, we've got a netting off, which leads to a favourable outcome for the employer. Your lordships will no doubt be acutely aware that the DIFC and Dubai in general can be a transient employment market. What the effect of the first instance judgment here is it says that an employer, notwithstanding that it has a claim for entitlements against its employee, which overtop any residual benefits payable to an employee, that the proper course for it to adopt is to pay out first and then seek to recoup whatever it says is owing to it. And we say that that simply can't be correct and would be manifestly unfair to employers, particularly where it's not uncommon that when people in the jurisdiction have their employment terminated, they can return to their home jurisdictions, they can leave the DIFC, they can leave Dubai, which leaves employers in a slightly impossible situation where either they pay out and risk not being able to get anything out of their counterclaim, or they don't pay out and they risk incurring penalties. So it's somewhat of an impossible choice. It's somewhat of an unfair choice. So the policy considerations and the fairness considerations certainly swing both ways. But as I say, that's probably enough by way of introduction. Coming on to the set-off argument itself, the starting point is paragraph 71 of the first instance judgment, which your lordships will find at A43. And it's the second sentence here which I'm referring to. What the judge said there is, for present purposes, ETG is not confined to Article 20. So that's a reference to the claim for a right to deduct from remuneration or to set off. And what he says, I'm satisfied that to the extent that the counterclaim is well founded, ETG is and must be entitled to set off the amount of the counterclaim against any sum otherwise due to TR, that's the respondent, in respect of his claims, including the penalty claim. I'll come on to Article 20 in more detail later with respect to ground 4 and why we say the judge was wrong, that this was a case that didn't fall within the scope of that article. But the key takeaway point here is whether Article 20 applies or not. The judge acknowledges that the appellant has a right to payment of the sums in its counterclaim and that it was entitled to set off those amounts against sums due to the respondent. So the question on this ground of appeal is therefore, in my submission, a relatively simple question about when a penalty claim is triggered and the entitlement to penalties under Article 19.2 crystallises. The legislative provisions are at E11. And I'm going to refer your lordships to these a couple of times. You'll no doubt be familiar with them, but given we're looking at precise points of construction, I think it's probably helpful to have them in front of you. So
the way this works on your submission is that the obligation under 19.1 doesn't arise if there is a set-off that overtops that, not including the penalty, any penalty payment.
Yes, so it's that the accrual of penalties is never triggered under Article 19.2 or 19.3.
And that
because
means 19.1, that means reading 19.1 as referring to a subsisting obligation, an entitlement. There's a gratuity payment and accrued vacation leave, an entitlement which arises out of other provisions, whether the contract or the employment law and so forth, and that entitlement is, as it were, extinguished for the purposes of penalty if there's a set-off that exceeds it.
Yes, correct.
Yeah, but you only find that out if the set-off is either conceded or established in a court.
Well, I suppose be that as it may, the question ultimately for the court, as I'll come to, is whether the sum is due or not. And if the court ultimately establishes that a payment is not due, then it's never triggered. I think perhaps the easiest way to explain this is to just tick through the legislative provisions and how that ultimately works, because
I know you're going to do that. Before you do that, there's a question at the back of my mind which you might bear in mind when you make those submissions, and that is the extent to which that primary contention, as it were, sets at naught the other provisions in relation to deduction, disputes, and so forth. I mean,
I suppose the other way of looking at that is that you don't get to the point of the employee having enforceable right to a penalty until the court's looked at it as well.
Yeah.
So the point is that when we're considering the question of whether there's a statutory right to a penalty, we're looking at there being a decision by the court. And when the court is deciding whether or not the obligations giving rise to penalties have been triggered, it has to look at the matters in the round. And we say that that is clear from the legislative provisions themselves. So the first point being, I suppose, a very simple point, that Article 19.1 says that the right to payment of Article 19.1 entitlements is to payment within 14 days after the termination date. The most material provisions for present purposes are then Articles 19.2 and 19.3. So taking those in turn, what 19.2 says is subject to the provisions of Article 19.3 and 19.4. An employee shall be entitled to, and the employer shall pay, a penalty equal to an employee's daily wage for each day the employer is in arrears of its payment obligation under Article 19.1. So the key word here in Article 19.2 is the word arrears. In other words, arrears means money that was owed to the employee but not paid. And so if nothing is owed, penalties cannot ever get to the point of accruing. Article 19.3 makes much the same point. So it says a penalty pursuant to Article 19.2 may only be awarded to an employee. Again, that may only be awarded as a reference to the fact that this is something being resolved by the court. If the amount due and not paid to the employee in accordance with Article 91 is held by a court to be in excess of the employee's weekly wage. So again, as with the requirement in 19.2 that an employer is in arrears, Article 19.3 clearly states that penalties can only accrue if there are amounts which are due to the employee but have not been paid. Moreover, there's an additional layer to Article 19.3 which sets a requirement that the amount in arrears has to be greater than the employee's weekly wage. So that effectively sets a de minimis threshold below which entitlements can never accrue. In other words, and I suppose this in part answers your lordship's earlier question, the imposition of a de minimis threshold means that an employee's right to penalties isn't automatic, but it's premised on the court actually calculating what sums fell due and payable to the employee at a relevant point in time. So reading Article 19.2 and 19.3 together with Clause 19.1, what the court has to do is conduct that point in time assessment of amounts that are due and not paid to the employee. And the relevant point in time under Article 19.1 is 14 days after termination. Now, logically, that point in time assessment cannot take into account accrued penalties, because at that point in time, no penalties will have accrued. It's only after day 14, once you've worked out what is due and what is not due, and that you've established it's over the de minimis threshold, it's only after that point in time that the penalties actually are triggered in the first instance. So we have to have the de minimis threshold being surpassed. And what we say is that if when you conduct that point in time assessment, there is either a sum payable which is less than the de minimis threshold, or in this case, a sum which on a net basis is actually payable by the employee to the employer, penalty payments can't be engaged, because using the language in Articles 19.2 and 19.3, there is nothing due or owing, and there is nothing that's in arrears. And for obvious reasons, of course, the de minimis threshold has never actually been surpassed. Now, bringing that back to the judge's reasoning in paragraph 71, what he said was ETG is and must be entitled to set off the amount of the counterclaim, and I stress this part, against any sum otherwise due to TR in respect of his claims. So if that is the case, what the judge logically ought to then have done is to work out what sums were otherwise due to TR in respect of his claims. And this is really the key part, at the relevant point in time. That is 14 days after termination. And once you conduct that set off exercise or that netting off exercise of the counterclaim at that point in time, what you get is the respondent owing the appellant around $13,000. So in other words, the fact that the counterclaim then overtops the claim is central to understanding why the entitlement to Article 19 penalties never crystallized at all. Because once you conduct that netting off exercise, it's clear that there's no arrears for the purposes of Article 19.2, nor is the de minimis threshold surpassed or ever reached under Article 19.3, because it's the employee who owes the employer and not the other way around. And what we say is that the legislative provisions there are clear, and once that logic is accepted, and once the right enshrined in paragraph 71 of the judgment is accepted as being correct, the errors in the judgment then become apparent. So if we go back to the judgment, it's at A63. And to paragraph 72.
That's
The judge,
I think.
Sorry, A
43, isn't it?
Sorry, yes, I've got it. That's a typo on my part. Thank you. And what the judge says there is, to the extent to which ETG sought to go further still and to contend that the counterclaim stopped the penalty clock from running, I'm not persuaded. First, in the light of this judgment, it is apparent that the counterclaim does not now overtop the claim unless the penalty claim is left out of account, for which there be no justification. Secondly, it is possible that there may have been some earlier points in time when the counterclaim did overtop the claim, depending on whether particular items of the claim and counterclaim crystallized before being overtaken by the penalty claim. And he then goes on to say that to ascertain whether and for how long that was the case would involve an excessively complex analysis. What we say is that the judge simply can't be right in that analysis there. First of all, the approach itself is wrong. So this isn't a question about the counterclaim stopping the clock. It's a question about whether the right to penalties could ever actually crystallize in the first place. And here we say that it can't have because there is no arrears in payment due to the right of set-off acknowledged by the judge already in paragraph 71. So the only answer to that question is the penalties never started to accrue. So you don't need to stop the clock. There is no clock that's actually running. The second point is that the judge's observation is wrong in saying that there's no reason to leave the penalty claim out of account. There is. Conceptually, it's a right which arises in a completely different way to the Article 19.1 right. Penalties are not post-termination entitlements. In other words, they're not part of those core entitlements under Article 19.1, which have to be paid within 14 days. The penalties themselves only exist by operation of statutory provisions once it's already established that there's an arrears of payment in respect of one or more of the Article 19.1 entitlements. But as I've said, we never get there. Given the difference in the rights and entitlements we're talking about, we say it's entirely reasonable to have left the penalty claim out of account, because that's what the legislation requires us to do when it sets the de minimis threshold and when it sets the trigger point for the accrual of penalties at 14 days post-termination in the first place. The third point we make on the reasoning is that the judge's analysis is also wrong to say that the way the appellant's case was framed would require the court to undertake a fluctuating daily account to work out instances where the claim is overtopped by the counterclaim. If you think about it, it's actually the other way around. What the appellant is saying is, yes, there needs to be a point in time assessment, but the only relevant point in time is what the net position is 14 days after termination. That is before the penalties start to accrue. To the contrary, it's in fact the first instance judge's reasoning that creates an old situation where, following that analysis through, the counterclaim did overtop the claim for around, I think it would have been about 4 weeks, because we've got the 14-day period for payment. We've got a net £13,000 payable at that point in time to the employer, and the penalties were accruing in this case, I think something around the region of $1,000 a day. So we do have an odd situation on the judge's analysis where for the first 4 weeks or thereabouts after termination, the counterclaim did overtop the size of the claim, but then the dial swung the other way. And what we say about that is the judge's logic there makes the legislative provisions difficult to follow. It can generate uncertainty and inconsistency of outcomes. So, for example, one could see that if the daily rate had been lower in this case, there could be instances where the outcome at trial would have been considerably different than, say, the outcome following an immediate judgment application. And it simply can't be right that whether a party wins or not in its case is contingent on the form of procedure before the court that's used. It simply can't be right that if this case had been resolved, for example, within 12 days, the respondent, the appellant would have won, but if it was resolved post-trial, the respondent would have. We say that would be a pretty unsatisfactory outcome, and that the logic there is at best unwieldy as compared with the court asking a simple question of what the parties' respective positions were 14 days after termination. So I suppose in short, our submission is on this point is that following through the judge's own logic, paragraph 71, reliance on the counterclaim must be sufficient to stop the penalty claim from ever being triggered, because there is no arrears of payment. And in fact, if one looks at other parts of the judge's own reasoning, in particular, if you look at paragraph 86, of the judgment. That's at A46. The judge appears to acknowledge that that is the correct trigger point for an Article 19 claim. What he says there, and this is in relation to penalties claimed for late payment of salary. He says, so far as is relevant, the trigger for an Article 19 claim is that payment was not made within 14 days after the termination date. So that's it. If that's correct, when one conducts this netting off exercise or the setting off exercise, the penalties can't be taken into account because at the relevant trigger point, they don't exist. The alternative construction of that provision, whereby the appellant is obliged to pay the respondent in order to avoid penalties in circumstances where in fact it's the respondent who's the appellant, would not only be unwieldy from a procedural perspective, but we say it would also be a manifestly unjust and unfair outcome, and one that's inconsistent with the judge's findings on the appellant's entitlement to set off. As I say, not to mention giving rise to a legal framework that's confusing and unworkable.
Now, on that, so the any entitlement to a penalty is defeated if you establish a set-off which overtops the entitlements to which 19.1 refers. When one gets down to 19.4, this will presumably cover a situation where it's broader in one sense. It covers a situation where you're asserting a set-off on your argument, that is a relevant dispute which requires waiver of the penalty, or I suppose the view against you is the dispute must be about the entitlements under one. And do we go in a circle and say, well, that also covers a dispute about whether the entitlements are extinguished by a set-off?
No. So I suppose this is a potentially, well, it's not going to be a unique factor of this case, because one can clearly envisage there are going to be other cases that come before the court where there's a counterclaim that overtops the value of, say, a small expenses claim. What ground one says is that we never get into the Article 19 penalties regime in the first place. So there simply isn't the relevant trigger point to engage it. And so that will be the situation anytime that you have a entitlement on the part of the employer that exceeds the entitlement on the part of the employee. Article 19.4 is going to cover a slightly different scenario, because let's say, hypothetically, one is dealing with a counterclaim that only covers part of the outstanding entitlement. What Article 19.4 would do there, we say, is permit the court, or indeed require the court, to stop the clock on penalties running once that is a dispute that is actually pending before the court. So that's one effect of Article 19.4. The other is that, of course, there doesn't actually need to be a counterclaim at all for 19.4 to operate. There only needs to be a dispute regarding the Article 19.1 rights. So let's say that's a quantum dispute. Let's say there's a dispute about whether an employee is entitled to that. Let's say there's a dispute about termination. So it covers that sort of situation as well. So there's no circularity of argument. They're covering different scenarios. But the starting point for assessing whether you even get into the Article 19 regime has to conduct that point in time assessment of whether the de minimis threshold is surpassed. And in order to do that, you have to ask, what was the net payment position 14 days after termination? And if you get an answer that's less than the de minimis threshold, or as in this case, requires the employee to make a payment to the employer, you don't get into the regime, full stop. And that's really the argument on the set-off point, unless there are any other aspects of it I can assist with, I was going to move on to what it is I say about Article 19.4 and the scope of ultimately what is a pending court dispute and at what point that comes into play.
And you're going to address the interaction with Article 20 in relation to deductions from an employee's remuneration. I think that was invoked at 65.
Yes.
Yeah, okay.
With that in mind, I'll move on to the pending court dispute point. I'll come back to. I will deal with Article 20 to an extent in grind 2, but I'll also come back to it on grind 4. The issue here, to some extent, raises a similar point of construction. So it's about effectively trigger points. So when a relevant dispute pending before court is triggered for the purposes of Article 19.4a of the employment law. And again, I'll ask you to bring it up. I know your lordships will be familiar with provisions, but given that we're doing a bit of a deep dive into it, it's probably worth looking at. It's at E11. And what Article 19.4a says is that a penalty pursuant to Article 19.2 will be waived by a court. That comes back to the point I make on whether it's discretion or not, in respect of any period during which a dispute is pending in the court regarding any amount due to the employee under Article 19.1. Now, we've already looked at the legislative context, and what I say about that from the outset is that the legislative intention behind Article 19.4a is clear. It's to avoid the problems that are caused by protracted litigation giving rise to disproportionate penalties. This is one of the provisions introduced into the employment law precisely because of the potential injustice and unfairness to employers that it was capable of giving rise to. And as we've already seen was set out in the consultation paper, the legislator's intention here is to avoid unreasonable outcomes. And we say it's in light of that policy intention the court needs to consider whether it adopts a narrower or a broader interpretation of the words dispute regarding any amount due under Article 19.1. In breaking this point down, there are essentially three ways that I approach this question in my submissions, each of which I say gets us to the same result. First, there's a textual analysis of the provision. Second, there's a contextual reading of that provision in line with the judge's other findings at first instance. And then the third is based on an analysis of the precedent that we have and where in previous decisions it has been held that a relevant dispute was triggered so as to suspend the accrual of penalties. So on the first point, the textual analysis, there are a couple of sub-points we make about this. The first is the relevance of the words amounts due, with particular emphasis on due, which in that context we say can only have the same meaning as it has in Article 19.3, which sets the de minimis threshold for penalties to accrue. And that is that the sum must be due to the employee but not paid. And what that requires in considering the operation of Article 19.4 is for the court to ask whether the sums claimed are due in the context of the employee's rights as a whole, and whether there is a dispute over that question of whether those sums are due. And to that extent, what we say is that the appellant's counterclaims are plainly relevant to the question of whether any of the entitlements set out at Article 19.1 are actually due. In other words, where you have a counterclaim that eclipses the value of the claim, it's a dispute that needs to be resolved in order to ascertain whether the employee is entitled to anything at all. So in this case, what we say is that there is a dispute regarding whether the Article 19.1 amount is due. And we say that that reading of the provision is also consistent with the language that's then used at Article 20 of the Employment Law, which deals with deductions and set-off. That's at E11 as well. I think it would assist your lordships if I read the relevant provision at Article 21 briefly. What it says is that an employer shall not deduct from an employee's remuneration or accept payment from an employee unless, and then it provides the specific categories in which a deduction or set off is permissible against that remuneration. Now, the important point here is that what we're talking about is a right to set off against remuneration. And that's precisely what the appellant is contending for in this case. It's saying that irrespective of the claimant claiming his entitlement to payment of remuneration for the purposes of Article 19.1a, we can set off the sums that you owe us from that remuneration. So when we talk about whether or not there's a relevant dispute, if you're asserting a right to set off remuneration as defined, that is a dispute about what the remuneration actually due is for the purposes of Article 19.1a. So in order to ascertain what that remuneration is, the court is required to look at the dispute as a whole, including the counterclaim, in order to determine then whether there's a relevant dispute under Article 19.4. So what we say is the case here is that where we have, as we did, an employer asserting a statutory right to set off, whether or not that was ultimately what the judge found to be the case, that is an assertion of a right to reduce the amount of remuneration payable, and it's that remuneration which is the Article 19.1a entitlement that is in dispute, which then stops the clock under Article 19.4. So that's the broader point. The existence of the counterclaim means that there is the sum in dispute. There's the second sub-point, which is an alternative, though entirely consistent argument that we say also demonstrates that the judge was wrong. And here I place the emphasis on the text any amount. And what we say those words mean is that all you need to stop the clock is for there to be a single disputed item under Article 19.1, because Article 19.4 says that a penalty will be waived where there's a dispute regarding any amount due under Article 19.1. In other words, it doesn't need to be the case that the entirety of the claimed entitlement is disputed, nor is it relevant that there's a partial admission of some entitlement. For example, in this case, where the employee asserts a right to payment of termination benefits that include a notice period, but where the employer argues that there is some entitlement, but only on the basis of termination for cause, giving rise to dispute in quantum. What the article says about that is if there's dispute about any amount, Article 19.1 penalties will be waived. And here we're talking about there being a pretty broad range of items that were in dispute. So under Article 19.1a, remuneration is disputed because it includes a challenge about the per diem allowance, the respondent's bonus. There's an issue on whether there's an entitlement to salary in lieu, and that was, of course, contested on grounds that the respondent was terminated for cause. And of course, that's even when you put aside my prior submission that the question of the overall remuneration due is still subject to the counterclaim. Under Article 19.1b, we also have a dispute about end of service gratuity because the quantum of loss is contingent on the outcome of the issues in termination. The same point goes again for Article 19.1c in relation to accrued but untaken leave. So the fact that the quantum of two of the heads of claim, so that's the annual return airfare and the repatriation ticket were admitted in quantum terms, we say is irrelevant, particularly where, as I say, there's still residual dispute as to whether those sums are due in light of the counterclaim, because all you need is for there to be a dispute about any amount. And what the respondent seems to say about this issue is that these were only minor disagreements over the quantum of certain issues. So that's its position when it comes to gratuity and accrued annual leave. And it says that entitlement to penalties shouldn't be defeated by what it refers to as the deliberate expedient of disputing termination with or without cause. And it makes a similar point that spurious disputes over bonuses could drive a coach and horses through the legislation. Putting this slightly dramatic language to one side, that submission doesn't really work on quite a number of levels. First of all, the respondent lost on all of those issues, so it's difficult to see how they could be characterized as spurious or expedient. And the second point is that they weren't minor quantum issues. The claim for bonus, combined with the issues turning on termination for cause, totaled well in excess of $100,000. The third point, I suppose this is a matter of policy and procedure, is unclear why the onus should be placed on an employer not to raise legitimate arguments in defense of a claim, as opposed to placing the onus on an employee itself not to bring spurious and inflated claims for their own entitlement. The notion being floated by the respondent is that the way that the employer should get around this is by bringing a prompt claim for declaratory relief before the courts. We say that suggestion is not only unfair on employers, but it's unworkable and excessively burdensome. And finally, I suppose in some ways the more important point is that the legislation is clear in stating that entitlement to penalties is paused by the existence of any dispute. So unlike, for example, the triggering of penalties in the first instance, there is no de minimis threshold in order for that provision to bite. So even if one were to accept, which we don't, that the nature of the disputes was minor or that the quantum involved was minor, the effect of 19.4 is still that it pauses the accrual of penalties. So really the point here is that you can't isolate out particular heads of loss and say, well, that was admitted and therefore penalty starts to accrue on that, even if there are still disputes as to other heads of loss. We say that analysis doesn't work, and it also leads me on then to the second broader argument I raised, which is how one views the textual analysis in the context of the judge's other findings, which we say effectively put the same textual argument I've just referred to in a slightly different way. And specifically, I'd refer your lordships to the respondent's argument at first instance that a separate penalty should accrue with respect to each item of termination benefit that is unpaid. So in other words, if there are 3 benefits that are unpaid, you get 3 lots of penalties. That's what was argued at first instance. And the judge's reasoning on that point is at paragraph 79 at A44. And what he says there at paragraph 79 is, in my judgment, this ETG submission is correct and I accept it. That is, that it's rejecting the respondent's case. First and tellingly, as a matter of language, Article 19.2 draws a distinction between the employer's payment obligations, plural, and a penalty, singular. Thus, though the employer may be in breach of a number of payment obligations, the employee's entitlement is to a single overall daily penalty equal to the employee's daily wage. There's nothing in the language of Article 19.2 warranting a penalty for each head within Article 19.1. Now, what I say about that is that the same point can be made by parity of reasoning when it comes to pausing penalties. We're talking about it being paused where there is any amount in dispute. What the statutory language doesn't say is that it's paused only in respect of each particular item that's in dispute. So the penalty, singular, is incurred in respect of a failure to make payment of the sums listed at Article 19.1, but it doesn't arise distinctly in respect of each head under Article 19.1. And similarly, Article 19.4 bites and stops the clock on penalties where there is a dispute about any entitlement rather than a dispute about each entitlement. So you don't, in the same way that you don't incur a separate and distinct penalty for each head of entitlement, you also can't seek to get around the effect of Article 19.4 by arguing that whilst certain heads in 19.1 are in dispute, others aren't. Otherwise, we say that would be akin to the reasoning that would allow separate and distinct penalties to run in respect of separate and distinct losses.
As to that, the trial judge's approach at 79 seems to have his construction informed by a proportionality consideration, which I think is reflected in the last sentence. So you wouldn't disagree with that, I don't think. Going beyond the needs of the policy objective.
Yes. Correct. And the policy objective here, as we've seen from the consultation paper, but also the laws of the DIFC volume, is to cut out disproportionate penalties accruing whilst there's protracted litigation. And so the reason one interprets these provisions broadly rather than narrowly, and why one can take the broad words used, the any dispute, used in that language and apply a broad interpretation to it, is in order to achieve that policy objective. In other words, whenever the court is deciding whether or not penalties freeze, it's not being asked to undertake an item by item assessment of what the points are in dispute in respect of each item. The question is there a dispute about any Article 19.1 entitlement? And if the answer is yes, then penalties are paused. That's what the words of the statute say. That's what the policy intention behind the legislation is, but we also say that it's consistent with the judge's findings at first instance on other issues and why you shouldn't be applying a penalty in respect of each head of loss. So like I say, there's a textual answer and there's a contextual answer. There's also another approach, the third approach I referred to, which is by reference to how the court has approached these issues to date, which I say gives us a good steer as to when a relevant dispute is triggered. And your lordships will note that I've referred to a number of cases in my skeleton argument as authority for the court's practice of, I would say invariably and without getting bogged down in detail of disputed issues, exercising Article 19.4 when there is effectively a dispute. And when I say a dispute, I mean a dispute in broad terms. And we say that approach is correct for some of the reasons I've already explained, because as long as there's any amount under Article 19.1 that's disputed, that's enough for Article 19.4 to bind. But there are a couple of cases I'd refer your lordships to which put another gloss on that issue as well. And this comes down to what is actually meant by the word dispute in the legislation. So first of all, if I can ask you to look at the Capro and Casey decision, which is at E55. This is an SCT decision. The facts in many of these SCT decisions aren't hugely relevant. It's really the points of principle that arise. But if I can ask you, first of all, to go to E57, at paragraph 14. You can see, first of all, it's in the first subclause of the first sentence, an acknowledgement that in this particular case, the defendant actually failed to file a written defense at all. And if we go forward to paragraph 29, this is under the heading regarding claims for outstanding salary, we can also see that in that case, there was also common ground over quantum entitlement of at least some issues in the case. So we see at the hearing, the claimant and defendant agreed that the total untaken vacation leave and public holidays amounted to 33.5 days. So in other words, there are issues of entitlement that are not in dispute, as the first instance judge in this case would have viewed them. But if we then go to paragraph 40, which is at E60, we can see a decision on Article 19.4, which is inconsistent with the approach adopted by the judge in this case. So what it says is the claimant filed his claim on the 6th of October 2019. As established here above, the termination date was the 17th of September 2019 with 30 days notice period. I will exercise the powers vested in me by Article 19.4a and reject the claimant's claim in respect of penalties in accordance with Article 19 of the Employment Law. So that is because the claim has been brought by the claimant while he's still in his notice period. Now, there are a couple of important points of principle we say arise there. First of all, not only were there undisputed claims in that case, but the defendant there failed to file a defence at all. And notwithstanding that, the court's conclusion still was that there was a dispute for the purposes of Article 19.4a. And what I would suggest about that is that it's difficult to understand how, as a matter of policy, a defendant who completely ignores proceedings and doesn't issue a defence at all should be in a better position than a party who actively defends proceedings and responds to them appropriately, as in this case. The second point is that the underlying logic of why penalties are suspended is because the claim was filed during the claimant's notice period. So the point in time at which the SCT judge views the dispute as crystallizing is the date on which the claim is filed. And that makes sense of some of the other findings, that is, why it wasn't relevant that no defence was filed, and why it wasn't relevant that there were certain issues which were conceded by the time you get to trial. What this means effectively is that the content of a defence doesn't actually matter to the operation of Article 19.4, because the dispute, the relevant dispute before the court, is triggered at the point in time that the claim is filed. And we find the same point throughout a number of these authorities. So the next one is at E61, which is Michael and Matida. This is another SCT decision. And what I'd refer your lordships to is at E65, paragraphs 31 to 33. So paragraph 31, first of all, says the claimant served her last working day on the 30th of October 2020, and pursuant to Article 19.1 of the DIFC Employment Law, the defendant was required to pay out the claimant's end of service entitlements within 14 days, being 13th of November 2020. However, the claimant proceeded and preemptively filed a claim in the SCT on the 4th of November 2020. Then paragraph 33 then says, furthermore, the accrual of penalties has not been triggered, seeing as the claimant has, as set out above, filed the claim on a preemptive basis. Article 19.4a directs the court shall have discretion to waive a penalty for any period of time where a dispute has been pending with the court. Therefore, I find, seeing as the claimant's claim was brought ahead of the 14-day grace period allowed to employers, there's been no breach by the defendant of its duties towards the claimant, and I dismiss the claimant's claim for penalties accordingly. Now, one of the points raised by my learned friend is to these cases to simply say that, well, they're not the same on the facts, and These are about preemptive claims, but that somewhat misses the point of principle here. The important point of principle is that the point of time when the dispute is triggered is when it's filed. In other words, the approach of the SCT has been to adopt a broad interpretation of Article 19.4, which says that as long as you have a claim before the court regarding the Article 19.1 entitlements, there is a relevant dispute, so as to stop the clock, or in these preemptive cases, to stop the clock from starting on penalties. And that claim is a dispute, whether it is defended or not. And that's significant because if the dispute is triggered from the point in time the claim form is issued or served, the content of the defense is completely irrelevant. So whether a defendant issues a blanket denial or actively defends or partially defends, or even, as in the Capro case, ignores the dispute completely, the clock stops until those proceedings come to an end. And that isn't just a line of reasoning that has been adopted in the Small Claims Tribunal, but I also refer your lordships to the Lyrissia and Lexi case, which is E70. Which is a judgment of Justice Wayne Martin. And the relevant part of that judgment is at paragraphs 26 to 31, which is at E73, which is the section dealing with penalty. Now, just to give what the context of this case is, here it was common ground that the claimant had commenced proceedings before the expiry of the 14-day period in Article 19.1. The issue in dispute there was that the claimant had asserted previous failures to pay salary, where effectively the debt was triggered at an earlier point in time under Article 18 of the law. So what they're saying is that could give rise to an early entitlement to penalties. The court rejected that argument. But it's the reasoning really at paragraphs 30 and 31, which are material to this appeal. And what's said there is it follows, and this is in respect of the cross-reading of Article 18 and Article 19, the appellant faces precisely the same difficulty in relation to a claim for penalty based on wrongful deduction from her remuneration as she faces in relation to her claims based on other entitlements. Namely, penalty could not commence until 14 days after the termination of her employment, which is more than a month after she commenced her claim. And then this, I suppose, to some extent gets into the policy considerations here, lest it be thought that this conclusion is harsh. It should be noticed that Article 19.4 expressly provides that penalty under Article 19.2 will be waived by a court in respect of any period during which a dispute is pending in the court regarding any amount due to the employee. As there has been such a dispute pending in court since a time before the time at which the penalty might otherwise accrue, it follows that Article 19.4 provides an alternative reason why the appellant's claim based on penalty must fail. So again, this is reasoning in the court of first instance, where Justice Wayne Martin is clearly saying that the dispute was pending before the court from the moment the claim was filed, whether the effect of that seemed harsh or not, although I'm not sure that we get into that sort of territory in this case. So for present purposes, it doesn't matter that this is not a premature filing case because the point of principle is the same. If the trigger point is the filing of the claim, the content of the defence, and therefore any partial admissions made in the defence, is not determinative of the question of whether a dispute is pending in court. And that then brings me on to the various errors we say exist within the judge's reasoning in this case. That's at A43 and paragraph 74 of the judgment. What's said there is first, as to Article 19.4a, there is no dispute pending in the court as to any relevant amount due to TR under Article 19.1. As already seen, the amounts in respect of both the gratuity and the accrued annual leave are admitted. It does not seem to me that the live disputes in these proceedings as to other amounts due to TR bring the matter within Article 9.4a. The purpose of Article 9.1 is to protect the employer against the imposition of a penalty with the amount owing to the employee upon which the penalty will bite is itself in dispute. That is not the case. Well, we say that that's wrong. First, the existence of the counterclaim is relevant as to whether any sum is actually due under Article 19. So where there was a counterclaim, there was a dispute about the remuneration actually payable to the respondent. And so there was a relevant dispute before the court. That's even on a narrow view of the legislation. The second, and again, even on a narrow view of Article 19.4, there were clearly amounts in dispute under Article 19.1. Beyond that, namely the bonus claim, the per diem claim, and the notice period claim. And we say that the existence of those disputes alone is sufficient to trigger Article 19.4 because there is clearly an existence of any dispute. The third point is that the judge was wrong on the face of what he says there to say that the gratuity and holiday claims were admitted. We say that's an unnecessarily narrow view of the dispute. As I've already said, the quantum of the claimant's entitlement was ultimately contingent on the outcome of the disputed issues on termination, which the respondent ultimately lost. But until the court decided that issue, the appellant had no way of knowing what the respondent's entitlement actually was. But the final point, and really the point that arises from all of these authorities, is taking the broader view, the view endorsed by the court to date. Ultimately, the basis on which the appellant pursued its defence is completely irrelevant, and an itemised breakdown of what issues were and were not in dispute is redundant, because the simple fact is that this dispute crystallised the second that there was a claim before the court seeking payment of Article 19.1 entitlements. And what we say the judge did here was depart from the consistent practice of the Small Claims Tribunal and the Court of First Instance when it comes to pausing penalties in dispute. And it's probably worth pointing out again, it's maybe more of a policy observation or an observation as a matter of procedure. What one has here is, if the judge was right, a situation in which effectively an intransigent and unreasonable employer is put into a better position than a reasonable employer. And what I mean by that is that one could take the view that the prudent course to adopt for any employer is simply to issue a blanket denial of any entitlements so as to put them into dispute for the purposes of 19.4, if one is to adopt such a narrow interpretation of that provision. What that will prevent employers from doing, where there are reasonable and legitimate disputes about the net sums to be payable between the parties, is prevent reasonable concessions being made, to prevent reasonable admissions being made, to prevent issues from being narrowed before the court, which in my submission would be an unsatisfactory outcome, and one that's not intended by the legislation, but perhaps more importantly, is not an outcome that is supported by the express terms of Article 19.4, nor the court's practice to date.
Mr. Doty,
Yes.
how long more do you think you'll be taking?
I don't think I'll be too much longer. The grounds 1 and 2
Okay.
occupy a lot more time than grounds 3 and 4.
Okay, good. Thank you.
That is all I have to say about ground 2. I'm happy to move on to ground 3 unless there are any points that I can assist your lordships with at this juncture. Okay. Ground 3 is the unreasonable conduct ground. Now, this is a point that arises from Article 19.4b of the Employment Law. Again, that's at E11. But what it says is that a penalty under Article 19.2 will be waived by a court in respect of any period during which the employee's unreasonable conduct is the material cause of the employee failing to receive the amount due from the employer. Now, the judge's finding on that point is at A44. at paragraph 75. And what the judge says there is that, assuming in ETG's favour, without deciding that TR's breach of fiduciary duty constituted unreasonable conduct within Article 19.4b, I am unable to accept that such conduct was the material cause of TR failing to receive timelessly the amount due from ETG. To reiterate, payments in respect of the gratuity and accrued annual leave are admittedly due to TR, regardless of its breach of fiduciary duty. There was nothing to prevent ETG making those payments punctually and stopping the penalty continuing to accrue. The means of extinguishing or reducing the penalty claim lay in ETG's own hands. Pausing for a moment, you've already heard from me on what I have to say about the gratuity and accrued annual leave being admittedly due. As I say, that conclusion needs to be taken with a big pinch of salt because it ignores the fact that breach of fiduciary duty was a central issue at trial. The questions of termination ultimately turned on the conclusion on that issue, and consequently the amounts actually owed turned on those arguments. But what was admitted there was the quantum in the event that the respondent was terminated for cause. But again, that was very much a disputed trial. Putting that part of the reasoning to one side, the judge says that he doesn't decide, but assumes for the purposes of the ratio of his decision that breach of fiduciary duty could amount to unreasonable conduct. And we say that that must be right. It must be correct to say that an employee breaching their fiduciary duty to its employer is unreasonable conduct. But ultimately, the judge's analysis on this issue turned on causation, i.e., whether the conduct was the cause of the employer's failure to pay the employee his Article 19.1 entitlements. Now, even if one takes a narrow view that the only unreasonable conduct in this case was limited to the breach of fiduciary duty in itself, and of course you'll note from my skeleton that we go beyond that to say that there's unreasonable conduct in refusal to repay loans and engaging in the litigation. But taking the narrower view, if one applies a but-for causation test, we say that the answer to that question must be affirmative, because if you remove the counterclaim from the equation, it's obvious that there would have been at least some net sum payable to the respondent in respect of his Article 19.1 benefits. But that isn't the situation we're in. There was a counterclaim. The existence of the counterclaim was the reason that end of service entitlements were ultimately not paid out. Now, when it came to the counterclaim itself, the respondent didn't admit his liability for the sums claimed as due, nor for that matter did he seek to make payments of those sums that he knew were owed to the appellant, that is, the admitted amounts for personal travel and a personal loan. And I've already referred your lordships to the net outcome of these proceedings, which is that the respondent lost in respect of a large number of the contentious heads of claims, including bonus and notice pay. The respondent lost on the termination for cause issue. The respondent lost on breach of fiduciary duty, and the respondent was ultimately found liable to repay a substantial loan and other amounts to the appellant, such that the net position following proceedings was that the respondent owed the appellant money. And in my submission, it is unreasonable for a claimant to assert a right to immediate payment of his entitlements, including through costly litigation, while simultaneously refusing to accept that the employer was within its rights to set off those entitlements against what the respondent owed to it. So the material cause of the employee failing to receive his payment from the employer here is that there was the existence of a debt which, when netted out, meant that sums were payable to the appellant. And the reason that the appellant and not the respondent was ultimately owed money in that way is a direct consequence of the respondent's breach of his fiduciary duties. That is his unreasonable conduct.
Mr. Doty, isn't it the case that under Article 19.4, the unreasonable conduct must be unreasonable conduct during a period? That's the opening words. And that's a period in which a penalty would otherwise apply. So we're talking about a period after 14 days post termination. So the breach of fiduciary duty is not the unreasonable conduct. you seem to be saying that the fact that he's contesting that issue with the employer is unreasonable conduct.
No, so what I would say that Article 19.4a says is that the reference to any period it's the period in time in which the penalty will be suspended. What Article 19.4b doesn't say is that the unreasonable conduct itself has to occur during the post-termination period. So
Well,
the conduct can come before. So
sorry, just looking at the text, it's a penalty in respect of any period during which the employee's unreasonable conduct is the material cause of the employee failing to receive the amount due from the employer. So you're saying it doesn't matter when the unreasonable conduct happens, if it has that effect during the relevant period. Is that how you're running it?
Yes, that's correct. So to give another example of this by way of analogy, one, I suppose, classic situation in which this article may apply is if you've got a situation where the employer writes to the employee prior to his termination and says, give me your bank account details so we can transfer the money to you, or here's a check, come pick it up in the office. And the employee doesn't do that, such that when you get to day 14, penalties would ordinarily start to accrue. The conduct, which is preventing the payment being made, occurred prior to the 14-day trigger point, but the effect of the conduct and the cause of the non-payment thereafter is the event that happened before. So by parity of analysis on that, what we'd say is that it doesn't matter that the unreasonable conduct predates termination. All that the court has to be satisfied by is that it is that unreasonable conduct which is the material cause of non-payment. And on that, what we say is that if it hadn't been for the unreasonable conduct in the first place, we don't get a counterclaim, we don't get to the net payment position that we have, and we would have a situation in which there would be entitlements payable without set-off. The reason payment isn't made is because of the existence of the counterclaim, and the reason the counterclaim exists is because of the breach of fiduciary duty. And so we say that there is a direct chain of causation from that breach through to the non-payment.
Yes.
And I suppose, and again, I come back a number of times to the policy considerations, but it is part of the overall context by how this case is going to fall to be decided. But there is also a bit of an irony here in that the appellant is being punished, we say, for making reasonable concessions in the course of litigation and on the first instance judge's analysis triggering penalties, where the respondent is in effect being rewarded for ignoring his own liabilities the other way around, including admitted liabilities on personal travel and personal loans, and in pursuing what we say was a largely unmeritorious claim. So if the respondent, we say, had owned up to the weaknesses in his case earlier, it is entirely plausible that the parties could have netted off their respective positions without protracted litigation, and in turn without these disproportionate penalties accruing. And as a bit of a postscript on this issue, I've already taken your lordships to the judge's reasoning on this, but one of the things he said is that there's nothing to prevent ETG making its payments punctually and stopping the penalty continuing to accrue. But as I already alluded to at the outset of these submissions, that's a pretty unsatisfactory interpretation of what an employer's requirements are. And as I say, that would clearly expose the employer to a risk of either having to risk incurring penalties while a dispute is ongoing, or to make a payment out and to subsequently go to court seeking to enforce its counterclaim. But as I say, Dubai is a transient employment market. The employer there is being asked to take a risk that it pays out the full amount that the employee asserts as owing before it gets to contest its own position. Meanwhile, the employee may no longer be in the jurisdiction. And so we say it as a matter of policy that puts the employer at enormous risk of being out of pocket, and that is another element of unfairness to the way that this question has been approached by the judge in this case. So, my lord, again, unless there are any questions, that's ground 3. I'll go on briefly to deal with ground 4, which is the recruitment of benefits point. That has to do with the effect of Article 20 and its interaction with Article 19. There are aspects of that I've touched on, but the starting point in the analysis is that Article 19(1)(a) requires an employer to pay remuneration within 14 days. So that's remuneration as defined in the legislation. In turn, the question of whether remuneration is in arrears for the purposes of Article 19(2), that is triggering penalties, or indeed whether entitlement to remuneration is part of a pending dispute for the purposes of Article 19(4), is in one view, and in my submission, influenced by the employer's statutory right to set off in Article 20. So Article 20, again, it's at E11. And what it says, as is material here, so it's a C, I'll touch briefly on D as well. An employer shall not deduct from an employee's remuneration as defined or accept payment from an employee unless C, the deduction or payment is a reimbursement for an overpayment of any remuneration or expenses, or to recoup benefits utilised by an employee in excess of their accrued entitlement under their employment contract. And then D, which is the other gateway that the judge considered in his judgment, was whether deduction or payment has been ordered by the court. The point here is that what's captured by the word remuneration for the purposes of Article 19(1)(a) must, we say, take into account the statutory set-off of remuneration under Article 20. So you can't view those as being distinct points. The remuneration that is payable under Article 19(1)(a) has to take into account the set-off. The first instance findings on this issue were that neither Articles 20C or D were engaged. Although, as we've already looked at in ground 1, the judge found that there was nevertheless a right to set off. But what the judge said about this, and I'll read it out, is that deductions from an employee's remuneration are not generally allowed. They are only permitted in a limited number of instances, all tightly drawn. I'm not persuaded that on the facts, ETG can bring the case within either Article 20C or D. No question arises here of reimbursement for an overpayment of remuneration, nor is ETG recouping benefits. Moreover, no deduction from TR's remuneration was ordered by the court over the relevant period when the payment was late. Accordingly, had this defence rested on Article 20, it would have failed. I did raise a point in my skeleton. I'm not sure that anything turns on it, but given that the judge held that there was nevertheless a right to set off, it's difficult to follow why that couldn't constitute a deduction or a payment ordered by the court for the purposes of Article 20D. So put differently, the appellant's entitlement to payment for breach of fiduciary duty is a payment ordered by the court, and therefore one that it's entitled to set off for the purposes of Article 20D. But be that as it may, this specific ground of appeal focuses on Article 20, and specifically the finding on ETG recouping benefits. And we say that the judge was wrong in his conclusion that Article 20C couldn't apply because there was no overpayment of remuneration. And the reason for that was, on the judge's reasoning, because the overpayments here were with respect to personal travel and a personal loan, which for the purposes of this appeal we accept do not fall within the umbrella of remuneration. But that's only one aspect of what's set out in the statutory provisions. The statute deliberately goes further than saying that there needs to be an overpayment of remuneration, but it includes benefits utilised by an employee in excess of their accrued entitlement. Now, a benefit isn't an expressly defined term in the employment law. In my submission, it should have its normal meaning. That is something that an employee receives by virtue of their employment, which is in excess of their accrued entitlement under their contract. Now, the respondent's argument on this point seems to be that personal airfare can't be a benefit because there must be some form of provision in the employment contract in the first place for it to be a benefit. With respect, we say that submission doesn't really work when one actually looks at the definitions that are set out in the employment law. So, for example, remuneration is a broad umbrella that captures wages as defined and additional benefits as defined. Additional benefits we don't need to be concerned about because it largely relates to bonus and discretionary bonus. But the former, wage, is further defined to include capital A, allowances, and allowances under the list of definitions in the employment law covers things like housing, travel, education, and so on. So following that through, business airfare is something that would be captured by the term allowance, forming part of the employee's wage, which in turn is remuneration. So the point then is that for the word benefit to have any meaning, it must be intended to capture some form of benefit that isn't caught by the broad umbrella of remuneration. And so in this instance, what we say is that this is clearly apt to cover things like the respondent's personal travel expenses paid out by the company, as well as a personal loan paid out by the company, for the simple reason that he wouldn't have had access to those benefits but for his employment. So the upshot of that is that we say that the judge was wrong to say that the appellant wasn't recouping benefits through its counterclaim, and that it didn't fall within the scope of Article 20C. We say that analysis is incorrect, and that there was, in this instance, a recoupment of benefits. And where that in turn gets us is that those overpaid benefits can be legitimately recouped under the statute from remuneration. It then follows that the appellant's right to make deductions has an impact on the quantum of any residual remuneration payable under Article 19(1)(a). And that's relevant to two things. First of all, whether or not penalties are triggered at all under Article 19(2), but also whether there is a dispute about remuneration under Article 19(4). And exactly the same point, I should say, applies when it comes to entitlement to gratuity under Article 19(1)(b), because Article 66(5) of the employment law also permits an employer to make deductions from gratuity where there's a statutory right to make those deductions. So the upshot of that analysis and why it's relevant as a ground for overturning the judge's reasoning is that if you accept that submission as being correct and that there was an entitlement to set off benefits that were overpaid, the first point is that once the set off is accounted for, the net position is the respondent owed the appellant money. And two, even if that approach is wrong, there's clearly a dispute as to the remuneration payable under Article 19(1), and that in turn triggers the operation of Article 19(4)(a). So both those alternatives effectively wipe out that aspect of the penalty claim, which is in issue in this appeal. That's all I have to say about ground 4. It may be that there is some more to say by way of reply, but I've tried to be as comprehensive as I can on those points. I'm happy to assist in any way I can.
Chief Justice, I think you're muted.
Muted. I'm sorry. Thank you very much, Mr. Doughty. Mr. Paget Joyce, how long do you think you will take?
Well, my learned friend has taken just short of 2 hours. I hope to be a little bit shorter, but there is some ground to cover.
Okay, I think we need a short break, don't we? 5 minutes toilet break or something.
5-minute break is fine.
All people,
Lord.
5 minutes or 10 minutes break. Come back when everybody is ready. We'll start again. For now, we'll just take a 5 minutes break. I will not put everything. I mean, I'll keep the picture on, the video on. I'll turn off the mic for a while. I'm going to disappear for 5 minutes. I don't know whether the others want to do the same. I'll come back in 5 minutes and 5-10 minutes.
I'm obliged, Your Honour.
Thank you. Yeah, Mr. Peter Joyce, I think you can commence.
Your Honour, I'm obliged.
Thank you.
Your Honours, there is a fundamental flaw at the heart of my learned friend's entire submissions and argument. The fundamental flaw is to conflate and indeed confuse set-off and counterclaim. That confusion has infected my learned friend's submissions, but the learned judge at first instance signally did not fall into that error. And in my submission, that is the key to this entire appeal. And that is the touchstone that I submit the Court of Appeal should bear in mind in approaching this appeal. Your Honours, I'll therefore take my argument as quickly as I can, and Your Honours have the benefit of my skeleton argument. The introduction on pages 2 and 3 deals with procedural matters. I'll leave on one side the procedural irregularity and procedural oddity, which has now largely been explained by section F of the appeal bundle, which I didn't have available when I was drafting the submissions for the purpose of submission. And indeed, it is always much preferable to prevail and succeed on an appeal, or resist in this instance successfully an appeal on the substance rather than on the procedure. Your Honours, I've set out the scope of the appeal. It's common ground that it is of limited scope. Paragraphs 9 and 10 of my submissions are common ground, and the basis on which permission to appeal was both refused and then subsequently given is clear from the orders of the court at the end of last year. The court has that available to it, and I say no more for present purposes. Page 5, I've summarised the judgment, and again, a lot of this can be simply taken as read. But at paragraph 20, I say that the penalty claim concerned a statutory entitlement under Article 19 of the DIFC employment law. Article 19 is set out at paragraph 62 of the judgment and in the authorities bundle for this appeal. And of course, the whole of the DIFC employment law has been reproduced at tab E between pages 1 and 41, and it may be convenient if Your Honours look at the statute, because it will be.
Mr. Joyce, I'm
Yes.
using the tab to follow your references to the documents. Would
Yes.
you so kindly give me the number like what Mr. Doty gave?
Yes, indeed.
A, such
Indeed.
and such. I can go straight to the page.
I'm going to do that, Your Honour.
you.
The employment law is at E1 and it runs through to E41. And it may be convenient if the court was just to look back at page D5 in the defendant appellant skeleton argument to see the title of ground 1 the court can see that the basis of ground 1 is set off of counterclaim. And that goes to the initial point that I made, because of course the court is fully familiar that a set off is a defence to a claim, and it is therefore a shield, not a sword. And it's right if one treats deductions, the statutory deductions enshrined within the legislation as set-offs. There are, in that sense, strict statutory set-offs. But as the court is also well familiar, a counterclaim is a sword, not a shield. It is there for convenience, because matters which should properly and conveniently be heard between the same parties are then before the same court and available for that purpose. And of course, very frequently, certainly used to be the case, that one would have a judgment on the claim and a separate judgment on the counterclaim, and it's the setting off between those two separate elements that gives rise to what the learned judge at first instance spoke of as the overall balance. So when he spoke about setting off, he was talking about a pure arithmetic sum. He was not talking about a set off as a defence to a claim, save insofar as, I say, deductions can be treated as such. And I say that by way of preface to taking the court in detail to the statutory provisions in question. And those statutory provisions are at page E11. Now, as my learned friend has already indicated, these provisions will be fully familiar to the court, so I will take them quite quickly, but it's important to look at in detail at what Articles 19 and 20, insofar as they relate to this appeal, actually say. Article 19(1), an employer shall pay to an employee within 14 days after termination date A, B, C, and D. So before we get into A, B, C, and D, what Article 19 imposes is a mandatory obligation on an employer and a temporal time for the performance of that mandatory obligation, namely payment of identified sums and time, i.e. 14 days after termination date. So what is it that is required? They are set out at A to D, and they are, as the learned judge at first instance rightly observed, payment obligations in the plural. For the court's reference, we've already seen that, but that's at judgment page 79, judgment paragraph 79. And paragraph 79 is at pages A44 to A45. So there are serial separate obligations which are remuneration, gratuity payment, a daily wage in lieu of accrued vacation leave, and for present purposes, we can leave D on one side. So one has separate obligations, of which 3 are presently relevant. Sub-article 2, first of all, it is obviously subject to the provisions of Articles 19.3 and 19.4, which I'll come on to, and we must ask in the present context as to whether one or both of those articles applies. But paragraph 2 says that establishes the penalty regime. It is absolutely clear that an employee shall be entitled to, and the employer shall pay, a penalty equal to an employee's daily wage for each day the employer is in arrears of its payment obligations under Article 19(1). Now, we've established that those are separate serial obligations, and therefore in our submission it is absolutely clear that if an employer is in breach of one of those obligations, then the penalty provision kicks in. And it really, in our submission, Sorry.
Sorry, these are all statutory obligations, aren't they? The remuneration in 19(1)(a) would pick up remuneration to which an employee is contractually entitled, but it gives it statutory force.
Yes.
And then the gratuity payment itself comes directly out of the statute, doesn't it?
Yes, it does, because that's Article 66.
And then the daily wage for each day of accrued vacation leave, well, that depends on whether vacation leave is given under the contract. So that would be, again, a statutory, giving statutory force to a contractual obligation.
Yes.
Yeah. Okay. So we're talking about statutory obligations the whole way around.
Yes. It's a statutory obligation, which is a reinforcement of the obligation, save for the gratuity payment, which is purely statutory.
Yeah.
So that's what we say Article 19.2 plainly says. Article 19.3 in our submission can be left on one side because it's of no present application. That's the threshold provision. I think that's again common ground, and the judge deals with that at paragraph 63 of the judgment, which for the court's reference is at page A41. So we then come to Article 19.4, and we have the two provisions both pending in the court regarding any amount due to the employee and the employee's unreasonable conduct. Looking at the terms of Article 19.4, it's talking about a penalty, and obviously a penalty only arises after termination. Pursuant to Article 19.2 will be waived by a court in respect of any period during which either a dispute is pending regarding an amount due to the employee under 19.1, but there again we say, having established that 19.1a to d are to be read disjunctively, the reading of those disjunctively at Article 19.1 applies equally, construing the statute as a whole, to Article 19.4a. And then in relation to 19.4b, that covers unreasonable conduct. But, and again, to pick up with respect, Your Honour, Justice French have made the point about temporal nature of Article 19.4, and that with respect must be right. I've already dealt in part with that by saying obviously that a penalty only arises after termination. And then one has the phrase which is qualified by the clause following the which, both as regards A and B, any period during which A, a dispute is pending in the court, B, the employee's unreasonable conduct is the material cause of the employee failing to receive the amount due from the employer. In our submission, well, the point which was put to my learned friend by the court is absolutely right. The statute is clear, and the temporal point requires the unreasonable conduct to relate to a period after termination. That's made good by the fact that here we're talking about penalties which arise only after termination anyway, and by the ordinary meaning of the words, any period during which the employee's unreasonable conduct is the material cause of failing to receive the amount due. And in any event, there was a clear finding of fact by the court of first instance in this regard. The court will have it firmly in mind. The court can look back at page A44 and paragraph 75, which is the clear finding of fact that there was no conduct which was the material cause of failing to receive the amount due from the employer. And in our submission, the Court of Appeal simply shouldn't interfere with a clear finding of fact in that regard. And indeed, it's a clear finding of fact which stands the test of common sense. So that's what I would say in relation to Article 19.4.
Before you leave Article 19, Mr. Page Joyce, can I just go back to what I was putting to you about the nature of the obligations in 19.1. Let's assume that we have something which is properly characterised as a set-off, as distinct from a counterclaim. I remember we used to get very exercised about this many, many years ago in the context of insolvency, whether you had to prove a counterclaim.
Absolutely. Yeah.
But the remuneration is contractual. It's given statutory force. But the question is whether that contractual obligation is vulnerable at the contractual level to reduction by reason of a set-off. And then the statutory obligation only operates on, as it were, the difference.
I think I will address that by reference to the particular heads of claim and counterclaim, because what one can see in that regard is what was clearly within 19.1 and what, which is the heads of claim, and what is how the heads of counterclaim, which are not properly set off, i.e. personal travel, personal loan, and the secret profits through breach of fiduciary duty, they are not within Article 19.1.
Yeah. I mean, the argument about a set-off might be a bit harder when you get to the gratuity payment, which is purely statutory, I suppose. Anyway,
well, let me deal with that now, Your Honour. Why would that be more difficult? Because what one is looking at is you have specific entitlements in 19.1. You have specific and strictly drawn abilities to permissions to deduct in Article 20. And obviously I need to make good my full argument with regard to Article 20 to see the whole picture, so that in a sense I'm being asked to anticipate what I'll come on to. But in my submission, when one stands back, and we can do this at the end of looking at 19 and 20 collectively at this juncture, perhaps we can come back and see whether there really is any point there, because the tightly drawn nature of the exceptions in Article 20, i.e. deductions, which could be termed statutory set-off, are very strict.
Yeah. Okay.
And perhaps, well, let me deal with that now, because obviously that's next in line.
Sorry, the only point I wanted to make was, and from your point of view, you would be saying that a statutory entitlement, the gratuity payment, is not amenable to set-off because it's a statute.
Exactly.
The point I was putting to you is that may not be the same for remuneration, which is contractual, and at the contractual level may be vulnerable to set off, with the balance being the remuneration that is statutorily protected. It's just one approach.
And that does come back to Your Honour's point quite early in Malone and Friends submissions, which was that in respect of these there is a minimum payment. And Malone and Friend then went on to make many submissions based on the position of a responsible employer, the necessary implication being that Expresso Telecom was a responsible employer. But they were in fact anything but, because they failed to honour the minimum obligations in relation to all of these matters, which were substantial. And that essentially is the point. So it comes back to the point that your learned friend, Your Honour made in relation to Malone and Friend submissions, and I respectfully adopt and recall that interchange at this juncture.
Thank you.
If I can go on to Article 20, and this is deductions. These are the deductions strictly drawn as Justice Sir Peter Gross found. An employer shall not deduct from an employee's remuneration, so absolute bar, or accept payment from an employer unless Article 21A doesn't apply in these circumstances, nor does Article 21B. Article 21D, my learned friend kept open, but in my submission, the door is only just ajar, even on my learned friend's submissions, and really it doesn't open at all for the reasons that the learned judge at first instance, Sir Peter Gross, found in paragraph 70 of the judgment, which is at pages A42 to A43. So the focus is on Article 21C for present purposes. And Article 21C is very clear. Insofar as this creates a right of statutory set-off, it creates a right in relation to overpayment of any remuneration or expenses and recoupment of benefits in excess of accrued entitlements under the employment contract. Now, Your Honours may be assisted by looking back at pages A50 through to A52, which is the annex setting out the figures. And one can begin at A51 because these are the figures for termination for cause, and the sections in green are the relevant sections. So the first item, the claimant's contention at first instance was nil, the defendant's contention at first instance was nil. The end of service gratuity, $76,265 and some cents, both for the claimants and for the defendants, with an elaboration of the claimant's case set out in that box. The accrued annual leave salary balance, $7,693, the same figure under claimant's contention as under defendant's contention. If one then goes over the page to A52, the next green box is annual return airfare, $7,671, the same both for claimant's contention and defendant's contention. Repatriation ticket, $15,000, the same for claimant's contention and for defendant's contention. And, Your Honours, if you do the arithmetic, which my learned friend has obviously done as well as I have, the sum of the green boxes in relation to end of service gratuity, accrued leave, return airfare and repatriation ticket comes to, the precise sum is $106,630, $106,630.77, with just over the $106,500 that my learned friend referred to. One then looks at the heads of counterclaim. And in this regard, my learned friend concedes that the personal travel and personal loan, he said he accepts for the appeal that they do not fall within remuneration, and that must, in my submission, be a proper concession. If they do not, certainly secret profits and breach of fiduciary duty, a damages claim, cannot possibly fall within remuneration. So on that basis, none of the heads of claim on which the defendant succeeded, and one sees those going back to A52, in relation to secret profits and then the cost of airfares and the repayment of personal loan. None of those fall within the strictly drawn deductions which are set out in Article 20 of the new employment law. And indeed, if one wants to see an example of a deduction which could be made contractually, if one looks in the bundle at C8, C being the section where the employment contract is to be found. C8 at clause 12.4, on termination of employment, the company shall pay the employee an amount in lieu of vacation days accrued but not taken. That forms part of the claimant's and therefore the respondent's case in this case. In the event that the employee has taken more holiday than has accrued from and including the date on which the employment terminated, the employee shall repay the company the corresponding sum. So there one has an example of an entitlement in the employer's favour on different facts, which would fall within Article 20. It's not this case. So when one looks at the heads of claim, the heads of claim amount to the $106,000 odd. There is nothing within the statutory set-off provided or deductions provided by Article 20 of the employment law. And therefore, the critical question is not, as my learned friend would have it, do all the heads of the counterclaim exceed the heads of claim net of penalty? Because he's doing what the statute expressly says should not be done. The proper question in our submission is, was the employer in arrears of its payment obligations under Article 19(1)? And the reason why we put it in those terms is because that is the wording of Article 19(2). 19(2) triggers an entitlement on the part of the employee to a penalty for each day the employer is in arrears of its payment obligations under Article 19(1). So we've seen the aspects in which the employer was in arrears. We've gone through A to D and come to the $106,000. We've looked at any deductions which could be set off under Article 20. Here, there are none. So therefore, when one comes back to the acknowledgement that this is not, other than in terms of statutory convenience and Article 20, a set-off case, it is a case of claim and counterclaim, the claim clearly is quantified in the sum of $106,000, to which the penalty applies under Article 19(2), and for convenience, matters of counterclaim, not set-off, were heard by the judge at the same time. He found that 3 heads of counterclaim succeeded, namely breach of fiduciary duty and in relation to the airfares for personal travel and the repayment of the personal loan. And those he quantified as, I've not done the sums, but he quantified. And then in the overall balance, he set off the sums under the claim against the sums under the counterclaim. And that must be, in our submission, the right way of doing it. Because under my learned friend's argument, what one has is a provision in relation to penalties, which is a statutory provision biting not only on that which is the concern of the statute, but also that which is the concern of something completely out with the statute and which forms the counterclaim and not a set-off, namely claims for breach of fiduciary duty and claims for reimbursement of personal travel and personal loan, which are matters acknowledged by my learned friend to be out with, not falling within the scope of remuneration for this appeal. So in our submission, that makes good the critical starting point with which I began my submissions, namely that the fundamental flaw in my learned friend's argument has been to conflate and confuse set off properly understood, be it legal or equitable, which actually doesn't arise at all on this case, with the strictly drawn statutory set off or deductions, which I have now demonstrated to the court do not result in any actual deductions from the sums to be awarded under Article 19.1. And it is that conflation which lies at the heart of my learned friend's case. But when one looks at the judgment, and we'll come back to this very briefly, I think in light of what I've just submitted, the judge signally did not fall into that error, because he treated the counterclaim, he treated the claim, he treated the counterclaim, and then he looked at the overall balance. So, my Lord, Your Honours, I can, with the benefit of that introduction, revert to my skeleton argument. And I'd paused at paragraph 20 on page 5. Your Honour, Justice French, you're on mute.
I know that. I'm just trying to get off it.
Right.
I just ask you, on your construction of the operation of 20 and 19, let us take the case that the employee has been terminated for cause, and the cause is that the employee has stolen a significant amount of money belonging to the company. And of course, the company takes recovery action. But the employee, what's the position with respect to the employer's obligations under 19 in that case on your construction?
Well, Your Honour, I think some assistance is derived from page E103 in this regard.
Yeah.
Because I think what Your Honour may be thinking about is, well, should the end of service gratuity be removed in those circumstances? And what paragraph 76 says in the consultation document is that gratuity payments in the UAE serve as an employer's contribution to an employee's retirement savings, and withholding an employee's gratuity payment for a single event that may constitute grounds for immediate dismissal holds the potential for gross unfairness in case of long-serving employees, especially considering the open-ended nature of what may constitute grounds for termination for cause under Article 59.4 of the current law. So I can well appreciate where Your Honour is coming from, if I can put it in those terms. An employee who behaves egregiously and perpetrates a massive fraud on the employer, should he or she be entitled to an end of service gratuity? Conventionally, it sounds odd, but once thrown back on the purpose of the end of service gratuity, which in essence is a contribution to retirement savings. So would the pension in those circumstances be attackable? And if not, then in my submission, odd though it may seem at first blush until you get to the purpose of the end of service gratuity, the end of service gratuity would not be interfered with.
And the same would apply in relation to, let's say, any outstanding salary entitlement. We're not talking notice, of course, money in lieu of notice, because we've got dismissal for cause and accrued annual leave. The employer would, on your construction, still have the obligation to pay that within 14 days and be subject to a penalty if it didn't pay it, notwithstanding massive fraud.
Of course, termination for cause, that would be immediate dismissal. Yes. So has the employee, all that the employee, on the case that you're putting to me, Your Honour, all that the employee would be being paid for would be being paid for his work during the time that he worked.
Yeah. Well, I mean, there may be entitlements that employee accrues which haven't been under the contract, which haven't been met at the time of the dismissal. And of course, accrued leave is one such entitlement. There may be others, some sort of special payments to which one would ordinarily be, and not linked to conduct. But they're impregnable against, on your construction, against a claim in terms of the obligations of the employer. Those obligations are impregnable against a claim that the employee has stolen a lot of money, which the employer legitimately seeks to recover.
Well, the recovery would obviously be under a claim in conversion.
Yeah.
And that would be out with the contract.
Mm.
Yeah, I think it depends on the terms of the contract rather than anything else, because my common sense says that if you commit a big fraud or even a small fraud and you terminate it for cause, I think you lose everything. I mean, it's difficult for me to, as an employer or anybody, to accept that if you committed a fraud or theft, and then you still say, I've got my right under the contract. I don't think that's a logical argument. I'm sorry, Mr. Joyce.
Well, but of course, it's not this case, and it's being posited by way of testing the argument. But another way of testing the argument would be to say, well, what happens if an employer, you could have two employees in exactly living in parallel universes, but the only difference is that one employee is paid in advance and the other employee is paid in arrears. And then this grotesque fraud is discovered. The employee who has been paid in advance would have been paid under the contract. Putting the point that's being put against me, the employee who's paid in arrears, unsympathetic though the jib of that particular employee may be cut in the circumstances, but there would be a disparity. And it seems it's an odd disparity.
Contractually, the person who has been paid in advance will have to pay back. Whether you can recover or not is another matter. Whether you can recover the actual amount is another matter. But he has to pay back. You know, I pay you in advance for 1 year. After 6 months, you misbehave. You pay me back your 6 months, which I've advanced you. Whether you are going to run away or whether you have money to pay back is another different issue. But legally, there is an obligation to pay back. That's how I would read it. Anyway, let's go on to the next issue.
But Your Honour makes my point, because what Your Honour said was that the employee behaving egregiously would only be required to pay back the 6 months, which would be post-termination. That is exactly my point, that it would be an entitlement up to the point of immediate dismissal and not thereafter. And that the employee paid in advance should be treated as the same as the employee paid in arrears.
I suppose a way of testing this more precisely would be if your client had stolen $71,000 US instead of retaining a benefit through COOL in that amount in breach of fiduciary duty, would his position be any different?
No, because termination for cause does not mean that end of service gratuity is lost. And that's clearly underpinned the original law. It was clearly a point which was recognised in the consultation paper. I've taken, Your Honour, to paragraph 76. So by parity of reasoning, the same position should exist. Now, I can see that you may feel that that's a harsher case against an employer than the present case, but this was all ventilated at before the court of first instance. It's quite clear that termination for cause does not affect end of service gratuity. It may affect the precise calculation, but it doesn't affect the entitlement. And my client was entitled. And indeed, when one looks back at A52, the competing contentions indicated the same sum. 76,265. So it wasn't really a point being argued. It was simply an arithmetic point which was being argued, not a substantive point. And in my submission, that was the right way for this matter to be approached. And then when one approaches it in the right way, one gets back to the application of Article 19, which I've taken the court through.
Good.
Thank you, Your Honour. Now, yes, I was going back to my skeleton submissions. I'd taken the court to paragraph 20, paused there to look at the whole of the relevant provisions of the employment law, because in my submission it's very important, as one should construe any statute, to look at it in its totality and not to segment it with regard to particular heads of appeal, which was essentially my learned friend's approach. One needs to look at it in its totality. Paragraph 21, I say, as might be expected, and this is redolent in the judgment under appeal, as might be expected, Justice Sir Peter Gross subjected the relevant provisions of the DIFC employment law to rigorous analysis. And then Article 19.3 at paragraph 22, I'm repeating myself if I read that, he identifies the 4 defences that the defendant appellant put forward. He subjects those to critical assessment, and he reminds himself, this is set out at paragraph 24 of the submissions, as to the clear purpose of an employee's entitlement to a penalty, being to reinforce the obligation on the employer under Article 19.1 to make the relevant payment specified under Article 19.1 promptly. Article 19.2 does so by way of the imposition of a penalty calculated on a daily basis and subject to Articles 19.3 and 19.4. Well, Your Honours, in my submission, that is a more concise and succinct articulation, but clear summary of the effect of Article 19 read as a totality, which I've taken the court to. And indeed, Justice Robert French was talking about the position in the Australian jurisdiction of being an economic deterrent to circumvening behaviour. And in my submission, that is very similar to what Justice Sir Peter Gross was saying here. And he plainly had in mind not only the wording of the employment law, but its purpose. Paragraphs 25 to 27 is a sequencing matter, and then one comes through to ground 1, which I've probably largely covered, but let me just go through pages 7 to 8 of my skeleton quite quickly. What I say is that by promoting this ground from the previous ground 4 to ground 1, the defendant appellant is essentially inviting the Court of Appeal to consider the effect of the set-off of the counterclaim before it's considered the detailed operation of the statutory regime set out in the DIFC employment law, which is what I've now done. And when the court comes back to look at the way in which the the defendant appellant puts their case, they do so on the robust basis that the penalty claim is removed. And we say that the problem with that approach is that this court is being asked to assume, for the purpose of ground 1, that which the defendant appellant must establish in its other grounds. And we say it doesn't. We say it's a matter of statutory construction. And its whole case on ground 1, namely that the appellant didn't actually owe the respondent anything, depends entirely on the total removal of the penalty claim, and it depends on the conflation of claim and counterclaim, one to be set off in the overall balance against the other, and a true set-off as a defence to a claim, which these counterclaims were not. Paragraph 30 subjects the learned friend's argument to forensic and linguistic analysis. It's all based on ifs and conjecture, which I pick up in paragraph 37, I'll come on to. Paragraph 31, the nub of the defendant appellant's case on ground 1 is that the court at first instance erred in concluding, and here I've quoted from the judgment, it's in paragraph 72, page A43, that reliance on the counterclaim is justified in assessing the overall balance between the parties, but not for the purpose of attempting to stop the penalty claim time clock from running. And that is where the learned judge at Court of First Instance was signally not falling into the very error that my learned friend falls into in the pursuit of this appeal. So it follows in our submission, paragraph 32, there is no error in the learned Court of First Instance judge's reasoning. We say it is impeccable. In context, it's clear that he was differentiating between the ultimate reckoning in terms of the overall balance from the manner in which those sums must be calculated under the statutory regime. At paragraph 33, we take the court to Court of First Instance at paragraph 72. And this is really of a piece with submissions I've already made, so I'll simply refer to that paragraph as I go through. The absence of justification to which the judge referred in paragraph 72 must refer to what he has recorded 3 paragraphs later on, paragraph 75 of his judgment, bundle A, page 45, where he said payments in respect of the gratuity and accrued annual leave are admittedly due to the claimant respondent, regardless of his breach of fiduciary duty. So just pausing there, Your Honour, that really answers and makes good the answer I've already provided to the point that was put in argument earlier. There was nothing to prevent the defendant appellant making those payments punctually, stopping the penalty continuing to accrue. The means of extinguishing or reducing the penalty claim lay in the defendant appellant's own hands. With respect, the learned judge at first instance is entirely correct. And my learned friend seemed to put an argument forward, advance an argument in some instances, on the basis that this was harsh on an employer. It's not harsh on an employer, because an employer has much broader shoulders than does an employee. They are able to obtain proper legal advice as to what the statutory position is. It's not difficult in our submission to follow, and it's clear that this employer didn't follow the statutory obligations. And then we make the point, which again I've already made in relation to Articles 21C and 21D, the point that the learned judge at first instance made, that these deductions are, to use his words, permitted in only a limited number of instances, all tightly drawn. And his conclusion at paragraph 70, page A42, was that he was not persuaded that the defendant appellant could bring the case within either C or D of Article 21, and he's given valid and cogent reasons for that conclusion, which in our submission is or are entirely correct.
The employment law, just in relation to your characterisation of employers, would apply to a very wide range of employers, wouldn't it? From small businesses to large corporations, or is there some sort of carve-out?
No, it does apply, but I suppose perhaps not a particularly legal submission, but it goes with the territory, Your Honour. Employers are there to make a profit and to put employees to constructive and profitable work, and that profit accrues to the employer. Well, if the employer has to abide by statutory provisions, be it a large employer or a small employer, that does, in my submission, go with the territory.
So this applies as much to a somebody operating a barista business as it does to a gigantic corporation with.
Well, the number of cups of coffee that I consume, a barista business is going to be a very profitable organisation. But leaving that that light-hearted comment aside, yeah, if you are an employer and subject to the employer requirements under a statute, you are an employer and subject to the statutory requirements. Yes.
Okay.
Yes, I think I'd reached paragraph 36 in the skeleton. In sum, the learned judge in our submission followed the statutory requirements. He did so having directed his mind expressly to them. He clearly did so because it's recorded in the judgment, and he did so to the letter in calculating the sums to be awarded under both the claim and the counterclaim, and then setting off one against the other in the overall balance. Paragraph 37 draws strands together. It picks up the defendant appellant's case under this ground being based entirely on conjecture and counterfactual assumptions, which really goes back to what I was saying in paragraph 30. For completeness, I looked at the amplification of this ground in the amended grounds of appeal. I've given the reference, it's in the papers at B23. Those paragraphs don't take the point any further. And in our submission, this Court of Appeal should unhesitatingly prefer the approach and application of the learned judge at first instance. Let me go on now to ground 2. And of course, having looked at the whole of the statute in one fell swoop, so to speak, a lot of the ground already covered covers grounds 2, 3, and 4, as well as ground 1. So this ground, the pending court dispute ground, is what Justice Sir Peter Gross has called the Article 19.4 defence. And I've provided the references in the judgment to where he has considered that, paragraph 73 to 75, bundle A 43 to 44. We say that there's scant elaboration of this ground in the amended grounds of appeal. Again, it's a couple of paragraphs which the court can read at its convenience. But Article 19.4a, again, providing the reference back to something we've already looked at, provides for penalty waiver in respect of any period during which a dispute is pending in the court regarding any amount due to the employee under Article 19.1. And this is essentially covered by the disjunctive reading of the whole of Article 19. We read 19.1, reading in sequence. It's clear that 19.1a, b, c, and d are disjunctive. That point is made good by the reference to payment obligations in the plural in Article 19.2, and therefore the same disjunctive nature must apply when one's looking back at those matters, which is what one does from the vantage point of Article 19.4. So what Article 19.1 requires is the payment of the gratuity payment, the remuneration, the gratuity payment, the daily wage in relation to accrued vacation leave, each and every one of those heads of payment. And here, as we say in paragraph 40, payments in respect of gratuity and accrued annual leave were admittedly due. Those payments had not been made. Those payments were required by Article 19.1, and there was nothing to prevent, as the learned judge found, the defendant appellant from making those payments punctually. And the same applies in relation to the airfare and the repatriation ticket. And paragraph 41, the defendant appellant doesn't dispute those findings of fact, nor in our submission can it do so. Again, to cite the words of the learned judge, he concluded that the means of extinguishing or reducing the penalty claim lay in the defendant appellant's hands. And so it did, as we say. Again, perhaps this is repetitious. A defendant appellant, the employer, must pay that which is statutorily required. And then, as the learned judge correctly observed at paragraph 74, there was no dispute pending in the court as to any relevant amount due to the claimant respondent under Article 19.1 within 14 days after the termination date. So the requirements of the statute, which we've now seen, were not satisfied, and the defendant appellant could have brought a claim for a declaration, as I say at the foot of paragraph 41, that it was not obliged to pay any sum or any element of any sum under Article 19.1 of the law. And Millennium Friends characterises that as being unduly onerous and burdensome on an employer. Yes, he says that any prompt claim for a declaration would be unfair and unnecessarily burdensome. In our submission, we don't see why that should be the case at all, because that would be the touchstone of a responsible employer. And it is the means of responsible employers protecting themselves. They look at what should be paid, they work out what should be paid, they pay what should be paid, and then, if there's any shadow of doubt, they can protect themselves simply by issuing a claim for a declaration of non-liability, and almost certainly that sort of claim is never really going to see the light of day if the employer has behaved responsibly. It will be recognised by the employee. The employee won't contest it because they've been paid what they're entitled to, and that is how matters should proceed. So when we look at that and come to paragraph 42 of the skeleton, that in our submission is a straightforward remedy. It may be belt and braces, it may be overkill, but if there's any shadow of doubt, that is a straightforward remedy which provides a full answer to the defendant appellant's argument on this count. And I'm afraid I had to use references to the earlier skeleton dated the 14th of January, because obviously with simultaneous exchange, I didn't have the benefit of the page references to my learned friend's most recent skeleton. But fortunately, most of what he says in that is carried over from what was said in the earlier skeleton argument. The matters itemised, and here I probably should look at those matters. If we go to page B42, please. There, the items per diem allowance, secret profits, unauthorised travel expenses. We say that none of those are within Article 19.1. My learned friend suggests that per diem allowance is within 19.1. We don't see that really as part of remuneration. We see it as separate and distinct, but really it doesn't matter for present purposes, because plainly secret profits and unauthorised travel expenses were not within Article 19.1. Therefore, as my learned friend concedes, they don't fall to be deducted. And then we look at the position with regard to a bonus, and this raises real problems if my learned friend is right, because the definition of a bonus in the employment law, one can see this in page E35. It's under the definition of additional payment. I think at one stage my learned friend used the reference additional allowance. I think the proper phrase is additional payment. Additional payment includes any bonus that is discretionary. So one has the recipe for inappropriate behavior on the part of an employer trying to challenge bonuses, or alternatively nickel and diming in relation to the entitlement to which an employee is entitled. We're back to the 1 dirham disparity point, which was raised and considered in Frontline. It can't possibly be the case. It cannot be the case in our submission that the whole payment regime set out in Article 19 of the employment law cannot be the case that that can be upended by a dispute over 1 dirham. And the way in which you get round that unrealistic and unsustainable conclusion is to recall the disjunctive nature of A to D in Article 19.1 and treat the matter accordingly. If there is any non-payment of any of those heads, then that triggers the entitlement to a penalty. So I don't think that I need detain the court much further in relation to that. The open sesame argument of paragraph 46 comes back to the same thing. And I say at paragraph 47 that that's sufficient to dispose of the matter. Then there are the cases to which my learned friend refers. First of all, Frontline. Well, of course, that was a pre-2019 law. It was a case which was decided before the change of the law. And my learned friend took the court to E94, which is in the consultation paper. But in our submission, that really doesn't take things further, because the important point is what is the actual wording of the present law. And as I understood my learned friend's submissions, he was acknowledging, well, he acknowledged that not all aspects of the consultation paper or process were carried through, and in light of that acknowledgement, which is absolutely correct acknowledgement, you can't one has to treat with a measure of circumspection what is said in the consultation paper, because what really counts is what the new law actually says, which was the purpose of the exercise with which I began my submissions. And my learned friend, certainly in the argument in January, ventured to suggest that the new employment law might have been applied to the facts of Frontline in a different way. Whether it would or it wouldn't is neither here nor there, because we're not venturing into relitigation of a past case.
The consultation paper itself just posed a number of questions. I mean, it identified some issues, but it might be thought to be of limited value in terms of construing the section. There was no final report prepared that might be seen as having informed the legislation.
No, exactly. Your Honour has the point. And plainly, the consultation paper had some effect, because not everything which was floated as a possibility in the consultation was fed through into the revised law. And Your Honour is absolutely right. One has to go back to the law, see what it says. As far as Carpro and Landry and the further cases that my learned friend relied upon, namely Michael and Matida and the Lyricia case, when one looks at these cases, they were cases, by and large, where the claim, if a claim for penalties was made at all, had been made prematurely. Certainly that is the case in Michael. It is the case in Landry, where there wasn't even a pleading of the penalty. It's the case in Larissa. And when one looks at Carpro, that clearly would indicate that any powers exercisable are discretionary, or for reasons. In that case, the court exercised its reasons in a way which is not applicable here, because again, that is also a case where the claim for penalties was brought prematurely. And as I say in the skeleton submissions at paragraph 49, the reasoning in Carpro is both laconic, being comprised in 3 very short paragraphs, and it is somewhat unclear. So in our submission, really, one does not derive any assistance from those cases, save that my learned friend says that the time at which a dispute arises is when the claim is filed. Now, insofar as those cases say that, they say that in the context of the prematurity of the claim, and therefore the claim for penalties not being well founded for that reason. But I have a conceptual difficulty. It may not be of any relevance to present purposes, and indeed isn't relevant to present purposes. But I have a conceptual difficulty with my learned friend's submission that a dispute crystallizes when a claim is filed. A dispute only arises, surely, when a defence and the claim is challenged, because there is a difference between claim and dispute. If the claim is accepted, there is no dispute. My learned friend seeks to rely on these cases for that rather startling proposition. He's put it on the basis that the simple fact is that a dispute is crystallized the second that the claim is before the court. That I do find odd, but I don't need to explore it because it doesn't arise on the facts of this case, and therefore can, in our submission, be left to one side. So far as ground 3 is concerned, the respondent's unreasonable conduct, Justice Sir Peter Gross rejected this in paragraph 75, page 44 of the bundle, and he did so, as I say, at paragraph 52 of the skeleton, having expressly set out paragraph 19.4b earlier in the judgment. This was at paragraph 62, page 41 of the bundle. And then not only did he set it out, the relevant portions in paragraph 62, he then expressly reminded himself of the point over the page A42, in paragraph 66 of the judgment. So he plainly had all of these matters firmly in mind. In doing so, he properly identified 3 elements which spring from the very wording of the statute. Unreasonable conduct. And he assumed that in the defendant appellant's favour. So the learned friend is pushing at an open door as far as the court of first instance is concerned, in saying, well, of course, a breach of fiduciary duty must amount to unreasonable conduct. That was assumed in his favour. So one must then focus on whether it was a material cause, and this comes back to the temporal point that was raised by the court and which forms part of my submissions, and also the material cause for failing to receive the amount due. And when one looks at the judgment, the learned judge found correctly in our submission that the defendant appellant's case founded on the second and third elements. See judgment paragraph 75, page 44 of the bundle. Put simply, the breach of fiduciary duty was not a material cause in the claimant respondent not being paid the sums to which he was entitled. I've then gone on in paragraph 55 to deal with further paragraphs in the earlier skeleton, the defendant appellant skeleton of the 14th of January, which was the only one that I had available at the time of drafting these submissions. And insofar, this is paragraph 56, insofar as the defendant appellant submits that it's somehow the respondent being responsible, in our submission, that simply is not borne out. And again, for the sake of completeness, I've looked at the amended grounds of appeal. I've provided the reference in the bundle at paragraph 57, and really that takes matters no further. And in our submission, this ground 3, is baseless. Of course, the reference to benefits also relates to ground 4, to which I now turn. And this ground concerns Article 21C of the Employment Law, and Justice Sir Peter Gross rejected that ground in paragraph 70, which begins on page A42 of the bundle and in fact tips over to page A43. If one goes back to Article 21C, it is quite clear that it concerns benefits utilised by an employee in excess of their accrued entitlement under their employment contract. So it's not just anything that the employer would like to claim back. There is a statutory provision which must be followed and which must be fulfilled. So going and looking at paragraph 61 of the skeleton, the first step in our submission is to ascertain the benefits to which an employee was entitled under their employment contract. And the second step, having done that, is to identify the utilisation in excess of any entitlement accruing. Well, we've done the test, and indeed my learned friend has rightly acknowledged that neither personal travel nor travel alone fall within remuneration or indeed benefits. There is no provision in the employment contract for personal travel. There is no provision in the employment contract for personal loan. And in our submission, paragraph 63 of the skeleton, the complete answer to the defendant appellant's case derives from the very wording they've used, personal. Those are out with, certainly not within, the scope of the employment contract. So if you don't satisfy the first step, then the first step being a precondition for the second step, you don't even need to consider the second step. And then the correctness of that conclusion can be tested, we say, against the defendant appellant's own articulation of its case. And for this purpose, I've taken the court to tab B, page 54. Sorry, it's the paragraph 54. Tab B, page 46. My learned friend sought to make this good in the course of oral submissions by giving the word benefit a massively wide definition, which it simply does not bear. Paragraph 54, he says, a benefit can therefore be interpreted as something that an employee receives by virtue of their employment, which is in excess of their accrued entitlement under their employment contract. Based on this definition, there is a strong argument that the air tickets, plural, constituted an overpayment of an employment benefit, given that annual return airfare was part of the respondent's employment benefits, but air tickets personal travel was not. The respondent was granted significantly in excess of his permitted benefits in respect of air travel when incurring the air tickets personal travel. Well, we accept the acknowledgement which is expressed in that paragraph that annual return airfare was part of the claimant respondent's employment benefits, but air tickets personal travel was not. And that is the precise point. And the remainder of that paragraph, and my learned friend renewed the struggle in the course of his oral submissions. But what he then tries to do is to manipulate that which is acknowledged not to be part of the claimant respondent's employment benefit into being an overpayment of an employment benefit. The inconsistency is apparent, and I make that good in the remainder of paragraph 65. Paragraph 66 concerns public interest, and given the limited nature of the permission to appeal, we say there is very little public interest. The only public interest may be in relation to the point that the learned judge made in paragraph 76 of the judgment, which is as to whether the waiver is mandatory or discretion, or a matter of discretion. And it's certainly true that in the DIFC court's practice, or the laws of the DIFC, the reissue of the laws of the DIFC, I should say, in the reissue, the waiver provision in Article 19 is treated as discretionary. That's questioned by Justice Sir Peter Gross. My learned friend addressed that by saying that there's no clear authority. It's been argued both ways, and he can see that it's up for argument. Well, that may well be right, and I wouldn't differ from the way in which my learned friend has put it, but it isn't up for argument in this case, and it would therefore be much preferable in my submission for the matter to be raised in a matter where it really is up for argument, and where proper argument and submissions are addressed at first instance, and if necessary taken further. So on that basis, we say that the further pursuit of the point in this appeal really is undesirable. Perhaps that's a better word than OTOs. I've then, for the sake of completeness, looked at other matters raised in the defendant appellant's argument, and I've dealt with those summarily, I don't think unfairly or unnecessarily succinctly, in paragraphs 68 through to 72. And as I say, the procedural irregularity and procedural oddity has to a large extent been addressed by section F. And as I also say, it's much preferable, particularly on an appeal of this nature, which raises statutory interpretation, for me to win on the substantive argument rather than on a procedural point, but I hold it there and put it before the court for what it's worth. But my main target is in rebutting the substantive arguments put forward by my learned friend, and in our submission this appeal must plainly be dismissed for substantive grounds.
Thank you very much, Mr. Joyce. Any questions from the judges?
Thank you.
Nothing from me, thank you.
Okay, Mr. Doty, you want to respond to that?
Yes, thank you, my lord. A few points from me. I'm just going to take them in largely in the order they came up. The first is my learned friend made a point, which he came back to a number of times, about the need to read the entitlements at Article 19.1 disjunctively. And he says that's how it ought to be read in the context of Article 19.4a. In my submission, that supports precisely one of the points I've already made to your lordships, which is that if there is any dispute about any of those items, what my learned friend says is the penalty starts to accrue. But that's problematic for the respondent when it comes to Article 19.4, because what Article 19.4 says is the penalties will be waived for any period where any of those disjunctive amounts have a pending dispute. So to use my learned friend's own turn of phrase, if there is any dispute about any of the amounts for the purposes of Article 19.4, that is enough to stop penalties accruing. So in order for 19.4 to trigger, you only need one dispute. For what it's worth, we say there are many more than that, and that the individual heads are captured anyway. But that's precisely the point. If you read that disjunctively, the existence of one single dispute about remuneration or entitlement, gratuity entitlement, whatever it is, stops the clock. And that doesn't have a de minimis threshold in the way that the employer's claim for penalty has to have. So it also doesn't matter even if it's a minor quantum issue. If there is a minor amount of quantum in dispute, still that is enough of a dispute before the court to trigger the effect of Article 19.4. The second point relates to some of the discussion earlier about the categorization of statutory rights and contractual rights, and whether it might be possible to set off one against the other. I'm going to come on to the terminology we're using around set off in just a moment, because I think there's a bit of a risk of that issue becoming a bit of a red herring on this appeal. But the simple point here is that there are statutory provisions covering, for example, deductions in relation to gratuity. So if your lordships were to look at Article 66 of the employment law, which deals with entitlements, end of service gratuity, what Article 66.5 says is that deductions from end of service gratuity can be made in accordance with Article 20. So if you've got an Article 20 deduction, that can be netted off against the entitlement to gratuity. So there are provisions which would allow a statutory right to be offset in much the same way as a contractual right. Dealing with the, I think, associated point about whether remuneration is a contractual right being given statutory force and whether it's then vulnerable to being set off. I think that's precisely the point that we are making with respect to ground 2 and what the proper construction of a dispute regarding any amount due is. And so your lordships may recall that I referred you to Article 20 in that context, and that's really part of the process of reading statutory provisions as a whole, which my learned friend, for what it's worth, seems to agree is the correct approach. But what that sets out is an employer's right to deduct sums from an employee's remuneration when one cross-refers that to what the residual right of an employee is under Article 19.1a, that is its right to remuneration, that has to be read in the context of a dispute about remuneration as a whole. So where there is an asserted right in a set of proceedings to make a deduction from remuneration, that includes those contractual rights your lordship discussed. So remuneration means wages. Wages in the legislation is defined as by reference to contractual rights. So if remuneration is disputed, whether it's by reasons of set off or counterclaim, I don't know that the distinction is important. There is a relevant dispute under Article 19.4. And moreover, where there is a contractual right to remuneration and a right to set off or counterclaim sums due as wages under an employment contract, that can also have the effect where if the amount of the counterclaim dwarfs the amount of the underlying claim, Article 19.2 can never be engaged. So we say that analysis isn't inconsistent with our case anyway, but really that brings me on to my third point, which is to some extent getting bogged down in that analysis of set off or counterclaim runs the risk of missing the core point. We're dealing with the legislative provisions. It's notable that the legislation itself isn't referring to either a set off or a counterclaim. I'd also note in passing that this argument doesn't really appear to have been articulated until this morning, but be that as it may, the point that my learned friend doesn't really deal with is how the judge framed this at paragraph 71 of the judgment, where he said, ETG is and must be entitled to set off the amount of the counterclaim against any sum otherwise due to TR in respect of his claims. Now, there's no cross appeal with respect to that finding. So the question then is, how do we read that finding in line with the statutory provisions, which, as I say, don't refer to counterclaim or set off? Instead, what is referred to there, as I've already taken your lordships to, is questions of amounts that are owed or due or in arrears to the employee at the relevant trigger point in time. That's 14 days post termination. So when you apply the judge's own and unappealed reasoning, what he's saying is that you can net off or deduct the amounts owed on the counterclaim against the sums that were otherwise due to the employee. Now, I'm not sure that I read paragraph 71 as the judge intending to make some formal or legal point about what a set-off is or what a counterclaim was, or that there is any significance of that term of art to the interpretation of the statutory provisions. What's important is the question of what are those sums otherwise due, and at what point in time do we make that assessment? The judge's view on that was that you had to include the penalty claim in the calculation, and that's the point that's under appeal. That's the point we disagree with, because when one looks at the point in time that you are, and I'll say, netting off the respective rights and obligations as between employer and employee, that's 14 days after termination. At that point in time, the court has to consider what the respective entitlements are, and it's at that point in time, by reference to the statutory provisions, that the court has to decide whether there is a sum due, whether it is owing, and whether there is a sum in arrears such that penalties kick in. And really, that's the error in the judge's reasoning that's actually under appeal. This issue of set-off provides us with the context or the netting off of these claims which inform that decision, but I don't think that there's any importance placed by the judge when he says set-off and counterclaim, and in fact he does seem to use them interchangeably at paragraph 71. So that's the set-off point. The next point I raise is about my learned friend's submissions about the dispute only crystallizing when there's a defense. And he said that he had some difficulty with the submission that a dispute before the court would be triggered purely by the issuance of the claim. I note that my learned friend doesn't provide authority for that proposition, and as I've already taken your lordships to, the authority of the Small Claims Tribunal, but also the Court of First Instance on this point, is that the trigger is the reference of the claim. So, for example, in the Capro case, there is no defense. So on my learned friend's analysis, there can't have been a relevant dispute, but that's not what the court found. Instead, it said that the dispute was pending before the court from the date it was filed. A similar analysis works in the Michael case. There, the 14-day period, so that's the 14 days after termination, whereupon penalties could have started accruing, expired on the 13th of November. But what the court said about that is that the claim was filed on the 4th of November, and therefore it was premature. But what also arises from that case is that an acknowledgement of service was not filed until the 18th of November. I don't have the precise date that the defence was filed, but one assumes that it's going to be a later date than the 18th of November, both of which post-date the 13th of November trigger point.
Are you therefore saying that if the employer had paid what was due to the employee before the claim was filed, then there was no dispute? The moment the employer failed to pay that amount, then the dispute is triggered.
No,
whereas
so
Mr. Patrick Joyce is saying there's still no dispute at that stage until defense is filed.
So my learned friend and the judge in this instance took a view that the dispute only exists in respect of heads of loss that are effectively not agreed. So there has to be a substantive dispute.
Yes.
The only point in time which you could come to know that is when someone files a defense setting out which points are admitted, which points are defended, and somewhere in between.
Yes.
The point that arises from the cases is that the defense doesn't have that effect, and that the historic practice of the courts to this point has been to say that where you have a claim for an Article 19.1 right that has been filed, that's when the dispute triggers. So it doesn't matter what the content of the defense is. The trigger point for there being a dispute before the court is the claimant's act of filing that dispute before the court, which is perfectly logical. At the point that there is a claim before the court for an Article 19.1 entitlement, it is perfectly reasonable to say that there is a dispute about that entitlement. Otherwise, the claim wouldn't exist in the first place. But really, the point is that there is authority on this. There is a case in which we have had a defense filed after the 14-day trigger point from when penalties incurred. But the court's analysis in that case was to say that because the claim was issued prior to the trigger point, that was enough to suspend the penalties.
Okay. Yes, thank you.
A short point on my learned friend's observations about the annual return airfare as distinct from the personal travel. In my submission, it somewhat missed the point. The point we rely on is that the annual return airfare is a contractual entitlement which falls within the statutory definition of remuneration because it is an allowance. So allowances form part of remuneration, and they include, as I said, travel, living expenses, that sort of thing, schooling. So in order for the word benefit to have any proper effect as distinct from remuneration, we say it has to be given the broader interpretation that we contend for. Otherwise, the inclusion of the word benefit would be largely redundant. So what Article 20 is referring to is an entitlement by an employer to offset overpayments of remuneration, but also overpayments of benefits, which don't fall within the umbrella of remuneration. And really, that's the point. That's why it needs to have a broader scope than what my learned friend is contending for. And then the final point, I suppose, is perhaps a more high-level point, but it comes back to the query rightly raised by your lordships as to whether the egregious conduct of an employee, in the example being given, stealing from his employer, whether contractual sums or remuneration or gratuity was payable to that employee, and penalties could thereby start accruing if the employer didn't pay those entitlements, notwithstanding that it may have recourse against that person for the amounts that have been misappropriated. My learned friend's answer to that appears to have been that, yes, that is the correct position, and the employer has to make that payment, and to some extent that, as he says, that goes with the territory. They would bring a claim in conversion, and that's out with the scope of the legislation. The Chief Justice rightly said that it's difficult to see why, both on an interpretation of the legislation, but also having regard to the policy considerations, an employer should have to pay anything in those circumstances. And I note that my learned friend says this isn't the case, but the points of principle here are almost identical. We have an employee dismissed for cause for reasons upheld by the court. We have an employee who's breached his fiduciary duties to the company to the extent that he received personal secret profits over $70,000. We have finding that he's also failed to pay back personal loans and benefits that he's obtained to the tune of around $50,000. And the net outcome of all of that was that he had an obligation to pay the employer that outstripped what the employer owed him. And notwithstanding, we find ourselves in a situation, it's coming back to what I said at the opening of my submissions, where an employee dismissed for cause on justified grounds who owes his employer money is making off with about $400,000, so a sum 4 times larger than whatever his entitlements had been removing the counterclaim. And we say that that is, on any analysis, a windfall and a finding of the type that would completely undercut the purpose behind the changes in the legal framework governing penalties that were introduced into the new employment law and were designed to prevent precisely this type of unfair and unjust outcome arising. And unlike Frontline, where the legislative provisions somewhat tied the court's hands, the court isn't faced with that scenario here, because we have legislation that we say on its correct analysis should be interpreted in line with what the appellant contends for, but clearly leaves it open to the court to give effect to that legislative intention. And really that's what we're asking the court to do.
But that's also for the court to determine, isn't it? If at the end of the day, the court says, no, he's not entitled to that amount because under the contract, he's not entitled to that amount, then you cannot apply penalty to that particular amount because he's not entitled to that amount. I mean, it goes back to finally the wording of the agreement, the employment agreement, or the wording of the statutory provision, whatever it is, to say that if at the end of the day the court decides that he's not entitled to that amount, then there's no way he can get anything, on that amount. The penalty cannot apply to an amount which an employee is not eligible to.
Yes, thank you. And really, that's precisely the point we make. It's not just a question about whether, from an academic perspective or from an analysis of entitlement, there would have been some contractual or statutory entitlement on the part of the employee. What you have to work out is whether the amount is due. And really, that comes down to looking at this dispute in the round to determine what the respective position on entitlements is between employer and employee. We say that that's consistent with what the legislative provisions provide for, and that is the sort of outcome that is intended by those legislative provisions. Those are the only points I had in reply. As I say, I'm happy to answer any further questions.
Okay, thank you very much, Doti. Any questions from the judges? I think they've gone into very nice detail. Yeah, Judge Shamlan?
No, I'm fine. Don't have anything special. Thank you.
Okay, let me say thank you very much to Mr. Doti as well as Paget's for the very detailed submission. But I see a lot of issues that we judges have to go through one by one.
I hate that Teams glitch.
So, judges, I say thank you very much to the parties and all those people involved. So judges, shall we leave this link and go back to the earlier link, the judges' discussion link?
Your Honours, before you do, may I make one point, not in relation to submissions made by either party, but in relation to how my learned friend characterised what the judge said at first instance in paragraph 71 of the judgment. And of course, the Court of First Instance judge doesn't have a voice at this stage, but my learned friend said in relation to paragraph 71 that at that point, the Court of First Instance judge uses set off and counterclaim interchangeably. I would invite the court to read what the Court of First Instance judge actually says in paragraph 71, and the judge does not use those terms interchangeably.
Let's read through the we'll read through the paragraphs again and make our decisions. I mean, that is how Mr. Doti reads how the judge, but we will go through them again, Mr. Paget.
Yeah, I take it no further. Thank you.
Thank you very much.
Right.
Thank you very much. Thank you very much again. All the best. Bye.